quit it, you two. Stop it. Hey, I mean it. Hello, everybody. I got a cat fight going on just to my left. Is C-Rex in here? If she's not, I have to call her. She told me to call her before I went live. Oh, okay. Hold on, guys. Hold on. Hey, you guys. Hello? Hey, Mama. I'm live. I am. All right, Mama. I'll see you in a minute. Love you. Bye. I just watched Snitch. I had a section of that carpet without the sticky on it. And he was sitting over here. And Billy swatted him, so he backed up. And then the carpet just kind of slid. And he was going like this, trying to catch the carpet as it slid off. It was great. I now have a floor full of stuff from my desk, but it was great. Are you guys that impatient that you're going to cause all kinds of ruckus to get your treats? Yes, I hear that. Let the shenanigans begin. Let me open up the second jar because there's not enough in this jar to do this. Get your nose away from this blade. Oh, man alive. You guys, I tell you, you're something. Stop it. Hey, get your nose out of there. Hey. Hi, Earl. Hi, Tiny. Oh, look at you. So patiently waiting. Oh, tiny little piece of plastic from the wrapper. Not feeding that to you guys. Yep, and then the overspill for Ava. All right, last toss. There. Yes, Ava, it's your turn, baby. Oh, you're so good. You're such a good girl. Such a good girl. Come on. Yeah, come on. Come on, baby. Aww. I love her sweet face. Oh. Well, the kitties are finally happy. It's been let's see, since about 9:15 that they've been very unhappy. And they don't understand yet when I say it's not time yet or wait. They don't get it. They don't get it. You get it. You listen to that. Where was I? Where was I during that time? I don't remember the day. Oh, hello, Linda Adams. Hello, Nana Laura, honey. Hello, Wire Mother. Hello, Eileen and Carlin. Hello, Buzzy Pug. Hello, Mortimer Duke. Uh-oh, I don't see Jerry yet. Jerry must... Oh, there he is. Hello, Jerry Matthew Boyd. Hello, Jenny Green. Hello, Charlie. Oh, Earl's trying to get down. Oh, he's got such a long body. Hello, Speedromans. Hello, Anna Banana. Hello, Spider-Man. Hello, whoever's texting me. Hello, C-Rex. I love you. See what you guys gotta put up with when you know you're part of my family. Hello, Penny. All right, let's see who this is. Oh, it's my monthly payment to X. Oh, actually, almost. Whoops. I will have to deal with that later. So a couple of fair warnings, guys. So, there's not court tomorrow. At least I know in Michigan there's not. Other than some places might do like arraignments or something. But because there's not court tomorrow, we're going to have a little bit of a longer stream tonight. Oh, yes, we are. And also, I had to drink copious amounts of water tonight. So there's your warning. I will take potty breaks. I am bloated like a barge and ready to float away. Not in Texas either. Aww. I think you'll survive. I think you'll survive. Look at Billy. Billy's hosting the show right now. He's got his own spot. He's oh, look at the camera. Billy, look at the camera. He's like, this is my show. I'll do what I want. Your moral support. I reached out to Jerry and I'm like, can you please try to help me get this case? And it didn't work. But luckily, Lone Wolf of Saul had my back again. That poor guy. I feel so bad. Squishy needs to hurry up and get better so that I can stop bothering Lone Wolf. Oh, that. I appreciate that. Do I need a hall pass? Well, I was screen recording it at the same time as I was begging for help. And but the thing is I was worried it was going to get taken down before I had the entire case. That was my fear. And I had 12 minutes left of recording time. And like my heart was going. Like the adrenaline rush from the moment the case ends until I find out if I have it or not. If they could bottle it, it's stronger than epinephrine. Hello, Marcotti. Pretty much. He at one time was the ruler. I love those so much. I gotta make new ones. With their chunky butt selves. You guys quit it in there. Earl, I hear you. Playing rough. They're playing rough. It's gonna be with the I don't think he does. He is such a good guy. He really is. We have Discord video called each other. Hey! That did not sound like playing. Earl, come in here. Snitch, stop it. Since none of them can go outside right now because of the storms, they're all acting like boys. They really are. They keep me young. Yeah, he is so intelligent. Like, insanely intelligent. Hello, Dark Zoomy! Only 100? I think you're off on your mathematics, my friend. All right. Since it's going to be a longer stream, we're going to get right into it. The first, did I put it at the first? I think I put it. Yeah, I put it at the first. The first one is the one that I begged Lone Wolf and Jerry, and I was gonna message Squishy, but I knew he couldn't help. But I was gonna message him for moral support. Oh no! Hello, Sheena Lee. Well, I hope they fix it.
All right. Last but not least, I'm going to call State of North Dakota versus Brian Lee Decker, 02-2026 CR 154. Present in court for the state, Attorney Tanya Duffy. Mr. Decker appears by reliable electronic means from the Barnes County Correctional Center. Mr. Decker, were you present in court when your rights were read to you earlier?
Yes, Your Honor.
Do you understand your rights?
Yes, sir.
One of the important rights you have is the right to be represented by counsel at every stage of the proceedings, including this one. The law presumes that people who are appearing in court for their initial appearance in custody, the law presumes those people are indigent, and ordinarily a public defender is appointed automatically to cover today's hearing. Before going on the record, the court received notice from the assigned public defender that you intended to offer a guilty plea today and waive your right to counsel. Is that correct?
Absolutely, yes.
Has anyone threatened you, forced you, or coerced you, or made any promises to you in order to get you to waive your right to counsel?
No, sir.
You understand that you don't have to waive counsel. I could order Ms. Chisholm to get back online and represent you today. You understand?
Well, sir, I don't want to drag all this out. It's going to come up in no, I'm just going to plead guilty. I'm just going to get it done with and not save the court's time and mine.
Okay, and so Mr. Decker, I just want to make sure I'm really clear and the record is really clear. You have the right to have counsel and you're waiving that right, sir.
Yes, sir.
All right, the court will find a knowing and voluntary waiver of the right to counsel. And the court finds that the defendant is aware of his constitutional rights as they were read at the beginning of the court session. Mr. Decker, have you received a copy of the charging document?
Yes, sir.
Do you have that document in front of you?
Yes, sir.
Well, he seems rather polite. He's yes, sir, and so mild-mannered, and what could go wrong?
Is your name spelled correctly in the upper left-hand corner of that document?
Yes, Your Honor. Yes.
All right. And you have the right to have me read that document to you in its entirety, or I can summarize the document for you. Which would you prefer?
We can summarize.
The state alleges on or about July 1, 2026 in Barnes County, North Dakota, that you committed 3 criminal offenses, 2 Class B misdemeanors and an infraction. In count 1, the state alleges that you committed the offense of driving under the influence, first offense within 7, in that you were driving or were in actual physical control of a motor vehicle under the influence of a drug or substance or combination of drugs or substances to a degree that renders you incapable of safely driving. As charged, that is a Class B misdemeanor. And we're going to talk about the penalties for counts 1 and 2 together because they're both Class B misdemeanors. In count 2, the state alleges on or about that same date in Barnes County, North Dakota, you committed the offense of driving under suspension. And Ms. Duffy, are you alleging that the suspension was alcohol related or child support related?
No, Your Honor.
Okay.
No, it's not.
So just stick with me. So that driving under suspension, the state alleges that you operated a motor vehicle at a time when your license was suspended or revoked for any in any jurisdiction for some reason that wasn't alcohol related or it wasn't child support related.
No, sir.
That offense is also a Class B misdemeanor. For both counts 1 and 2, the maximum penalty for those Class B misdemeanors, maximum penalty is 30 days in jail, a fine of up to $1,500 or both, court fees totaling $250. On count 1, the driving under in the influence, there is an applicable minimum mandatory penalty. The minimum mandatory penalty is a requirement that you obtain an addiction evaluation from a licensed addiction counselor. There is a minimum mandatory penalty of a $500 fine. And on counts 1 and 2, there is a minimum mandatory requirement that you submit fingerprints for inclusion in law enforcement's databases. Count 3, the state alleges on or about that same date, July 1, 2026, in Barnes County, North Dakota, that you committed the offense of unlawful possession of drug paraphernalia for use with marijuana or tetrahydrocannabinol. That is an infraction. An infraction is not punishable by jail. The maximum penalty for an infraction is a $1,000 fine, no applicable court fees, no applicable minimum mandatory penalties. For all 3 offenses, if your conduct caused any loss or financial harm to another person, the court can order restitution. For all three offenses, if you're not a United States citizen, a conviction can result in significant adverse immigration consequences. For all three offenses, if you're convicted of any one of them or all of them, there might be additional collateral consequences for which the court is not required to explain. An example of a collateral consequence, one among hundreds, if not thousands, of collateral consequences that might apply. In count one, if you're convicted of a driving under the influence, and in count two, if you're convicted of driving under suspension, it likely will result in an additional consecutive license suspension or disqualification period. With respect to count one, understand that if you get another DUI within 7 years, or if you get another 3 DUIs within 15 years, the offense gradation increases and the maximum penalties increase and the minimum mandatory penalties increase. For count two, if you're able to restore your driving privileges within 60 days of the driving offense conduct date, so 60 days of July 1, you can move the court to dismiss the charge if you're able to restore your driving privileges within 60 days. If you're not able to restore your privileges within 60 days and your case is still pending, but you are able to restore your privileges while your case is still pending, sometimes the prosecutor will move to amend the charge or dismiss the charge, even though I can't force the prosecutor to do that or require the prosecutor to do that. Sometimes they still move to amend or dismiss the charge, even though they don't have to. You understand the nature of the charges and penalties as I've read them?
Yes, sir. Yes, Your Honor.
Do you understand that you can move to dismiss count two if you're able to restore your privileges within 60 days?
Yes, I could do that today, really. Well,
I'm just making sure that you understand that if you enter a guilty plea, you won't have that option. If you enter a not guilty plea, you would have that option if you're able to restore within 60 days. Understood?
I understand that. Then there's the option of bond and not being bonded out, and I'd rather not have to. It's all about money. I can't afford the whole pile of it. So I'd
All
rather
right.
stick and work with it.
Just to be clear, you understand the charges and the penalties.
Yes, sir.
I am going to ask you for a plea of either guilty or not guilty to each of these three counts. If you enter a guilty plea, your case will be over today. If you enter a not guilty plea, we will set your bail and schedule further proceedings. Do you understand what happens if you plead not guilty?
Yes.
Do you understand what happens if you plead guilty?
Yes.
And Ms. Duffy, is there a plea agreement in this case?
No.
And so just to make sure, Mr. Decker, that you understand, the state is going to give me a sentencing recommendation if you plead guilty. And you can give me a sentencing recommendation if you plead guilty, but I'm free to impose whatever sentence I think is appropriate or just, and it might be harsher than what you would expect. It might not be, it might be the minimum mandatory penalty. But I want you to understand that I don't have to follow what the prosecutor is recommending. It's just that a recommendation.
Yes, Your Honor.
Understood?
Yes, sir.
So in count one, driving under the influence, do you plead guilty or not guilty?
Guilty.
Count two, driving under suspension, do you plead guilty or not guilty?
Guilty.
Count three, unlawful possession of marijuana paraphernalia. To that count, how do you plead?
Not guilty. What? If you want to drag it on court, I'll plead guilty. Guilty. I ain't saying anything about on a bond or anything.
I'm a bit confused. I want to make sure I understand.
I'm
Mr.
guilty
Decker.
of unlawful possession of drug paraphernalia, yes.
So, Mr. Decker, are you pleading guilty or not guilty?
Guilty.
So the court will enter those guilty pleas. Has anyone threatened you, forced you, or coerced you, or made any promises to you in order to get you to plead guilty?
Nope. No, sir.
You understand that by pleading guilty that you're waiving all the rights that the court has to you before?
Yes, Your Honor.
Do you understand that you're waiving any and all defenses that you could have had, any and all non-jurisdictional defects in the case if there are any, and you're limiting your ability to appeal the case if you enter non-conditional guilty pleas?
Yes.
And do you still want to plead guilty?
Guilty.
Are you doing so freely, knowingly, and voluntarily?
Yes,
Do you need any time to speak with a lawyer about your case?
no,
And my understanding is that there is no plea agreement in place, so if the court accepts your pleas, I will do so on an open plea basis. Do you understand that?
yes.
All right. Ms. Duffy, a brief factual basis, please.
In this case, back on July 1st, 2026, Trooper Mishler was on patrol with the North Dakota Highway Patrol. He conducted a traffic stop of a vehicle on I-94 near mile marker 284 in Barnes County. Trooper Mishler had previously been provided information from a different trooper, Trooper Wenger, that he had witnessed the driver who had matched the description of an individual who had suspended driving privileges based on who the registered owner of that vehicle was. Trooper Mishler also observed the vehicle driving onto the yellow lane of the driver. As a result, he conducted a traffic stop. He made contact with the driver, who was the defendant. He identified the passenger as Timmy Linderman. Upon his approach, Trooper Mishler believed that the defendant was under the influence of controlled substances, specifically drugs. He conducted field sobriety testing on the defendant. All of those tests indicated impairment. The defendant, Trooper Mishler, believed he was under the influence of a controlled substance stimulant based on his testing and his experience. Subsequently, he was placed under arrest. In the meantime, the passenger was also placed under arrest for an outstanding Barnes County warrant. Search was conducted of the vehicle. Within that vehicle, they found some drug paraphernalia for use with marijuana. And at the time of this offense, the defendant's driving privileges were also suspended.
Mr. Decker, is that what happened?
Yes, sir. I was, in short, I was escorting a friend or an acquaintance, a guy I had run into, says he's from the area, and he was wanted to see his mom, so he was bringing him out this way. I work at the data center in Fargo. I was bringing him out this way. I wasn't looking at enjoying time out. I paid $1,000 to get my license off suspension. I paid out my butt to get the thing registered and everything like that. So I'm like one payment away to get my insurance and license out. I had to get my permit. Purchase his insurance in the permit. And so I was like staggering. So here I am today with that driver suspension thing. I got so much money tied up into that. And I was like $110 insurance, $29 insurance and a permit, and bam, I'd be legal.
Oh, whoa, buddy. Breathe. Take a breath.
But apparently I wasn't. And as far as using drugs, I've been sober for over a year. I take Vyvanse. I have a doctor's prescription. I'm working on my medical card. The same doctor. As far as the marijuana stuff, that's not mine. The possession of it, but it's on the docket. I'm pretty familiar with the court systems, and I don't have enough money to pay bond and all that stuff. I'm not really wanting to do all that. I'm working with the Ridge, a whole bunch of people in Fargo. As far as like the status I'm on today, I don't know much more I can tell you. As far as actual using any drugs or DUI, no, but I am on a prescription Vyvanse, which may have, so, and then I took a urine test. He breathalyzed me. Of course, I blew zeros. I don't know what more you want from me. I'm not really enjoying the court system anymore in my life. I've been sober a year and I'm trying to get away from it all appropriately. So my fastest way I'm thinking out of jail is to plead guilty and leave it to your honor's hands, because I don't believe in my knowledge. I am on a medicine. I have it in my backpack. I have the prescription. I have my weed card. I have everything but my legal license to be pulled over, and that's a $29 insurance payment, which I was going to do yesterday, but I couldn't get a license company because I had a permit and then take the test. I got $1,000 to get free of my suspension. I got all this money. I just can't keep on doing it. And now I work at the data center. I'm probably going to lose that job if you keep me in jail. So that's $110,000 a year. So I'm not messing up.
This is his idea of laying a factual basis. Basically denying all responsibility, claiming that the marijuana wasn't his. He has a prescription for Vyvanse, and he was seconds away from having his driver's license, and it's just an unfortunate situation. Sir, that's not how factual bases work. You have to take accountability or you don't get to plea.
I'm not doing nothing wrong. I really am not.
Mr. Decker,
Was
I
there
want to make sure, stop talking now. What I heard from you is I was driving fine. My license is almost restored.
Yes,
The
sir.
weed stuff isn't mine and I have a valid prescription for it. The drug that I was under the influence of is a prescription drug
Yes, sir.
and that I was taking it as prescribed. So what you're talking about sounds like a whole lot of defenses.
Yes.
And you also mentioned that you're pleading guilty just to get out of jail, not because you are in fact guilty. Those are generally things that are problems for me because I don't accept guilty pleas from people who aren't guilty of the offenses.
Thank you, Your Honor, for listening. I don't feel
So
guilty. I
You
don't.
need to stop talking. Like, just close it.
I'm sorry.
So your speech is also very, very pressured and fast. And it causes me some concerns that you might still be under the influence of some form of stimulant. I know you were arrested yesterday. I have some concerns about this plea because you're not telling me that you're in fact guilty. You're telling me a whole bunch of things that constitute defenses. Are you telling me otherwise now, or are you telling me not to accept your guilty pleas?
I'm not guilty. I'm not guilty, but I'm pleading guilty. You're the judge. You decide. Either way, I'm gonna go to jail. I can't afford to fight your whole shit. And either way, I'm in jail.
You need to make sure you're not swearing in my courtroom.
Sorry.
You might not be
can't
physically
afford to- I
present in
can't
my
afford to-
courtroom, but you're talking
I
right
can't-
now and you're swearing again. Stop.
I can't afford to fight your court system. I'm not giving time. I'd rather be guilty and get it over with. As far as your opinion of me being on drugs, cancel that because I am not.
Yeah,
Okay.
so,
You're reading the screen and you're profiling up.
all right, you need to stop talking.
How you're doing. I'm not guilty, but I plead guilty. I'll end it there. Rose, you give me 30 days anyway. So,
I asked the court to set bond, withdraw his guilty pleas and set it for further hearings.
I'm guilty. I'm not having that.
Sir, stop talking.
I'm guilty and I want to be charged guilty. I'm not dragging your
Stop
court
talking.
system. I am
We're
guilty.
done. I'm going to withdraw the defendant's guilty plea. I'm going to set bond. Sir, if you talk again, I'm going to mute the jail. You're talking out of turn. If that doesn't work, sir, I don't know what else to tell you. You need to hold off right now, okay? So I'm telling you to stop talking.
Yes,
You need to follow the court's order. You understand?
yes. I'm losing $110,000 an hour job, a year job right now.
So
So what I'm gonna do if you keep me in jail. $110,000.
don't talk out of turn again. I'm asking you, do you understand my warning?
Yes, sir.
Now follow the court's order, which was to stop talking.
Thank you.
I am withdrawing the defendant's guilty plea. I have not accepted them. I have not found that they were freely, knowingly, and voluntarily entered, nor have I found an adequate factual basis. So under Rule 11D, the defendant has the absolute right to withdraw a guilty plea. I'm not accepting the defendant's guilty plea. Was a request by the state, and frankly, that was what the court was going to order anyways. So I'm granting that request. Pleas are withdrawn. Not guilty pleas are entered on behalf of the defendant. I'm going to hear first from the state on bail, and then, Mr. Decker, I will give you an opportunity to be heard on bail. But you need to remain silent until I hear from the state. Ms. Duffy.
In this case, Your Honor, the defendant, his criminal history begins in 1991 with several NSF and no account cases, disorderly conduct 92, possession of marijuana. There's quite a few driving under suspensions along the way. Burglary 97, forgery 1997, criminal trespass 1998, felony bail jumping 1998, violation of protection order 2001, drug paraphernalia 2001, felony protection order violations times 10 in 2001, attempted violation of protection order 2001, two separate cases of forgery in 2002, felony theft in 2007, forgery 2007, some more NSFs in 2010, simple assault 2010, marijuana 2010, drugs in a motor vehicle in 2010, ingestion 2010, forgery times 4 2010, DUI in 2012, harassment in 2018. He's got more driving under suspensions in 2018 and 19. Fleeing in 2018, another in NSF in 2019, theft times 2 and forgery again times 2 in 2020. Another forgery, separate cases in 2020, petty theft 2020, violation of disorderly conduct restraining order and orders prohibiting contact in 2020. 2 separate cases of the disorderly conduct restraining order violations, disobedience of a judicial order in 2020. Another incidents of the violation, disorderly conduct restraining order and disobedience in 2021. Unauthorized use times 2 and theft of a credit card in 2021. Possession of meth in 2021. Felony meth and drug paraphernalia in 2021. Possession of marijuana 2022. Disobedience 2022. Possession of meth and criminal trespass in 2023. Resisting law enforcement 2023. Felony drug paraphernalia in 2025. Some infraction marijuana times 2 in 2025. Felony meth and felony drug paraphernalia from 2025. He should be on parole right now for that. He received a 2-year sentence that was imposed in July of last year, so he should be on parole, presumably because it's not been 2 years since last July. So he should be on parole status for that last case. I didn't check about probationary or parole statuses for the cases before that.
He probably only skipped a year by way of being incarcerated, considering she just mentioned parole or probation status. That seems to be the only way that this guy can stay out of trouble.
The defendant has a Drake, North Dakota address, so I don't know that he has any ties to Barnes County. I don't think any of his cases really came out of Barnes County. There's some in neighboring counties, but not Barnes that I recall seeing. I'd ask the court to set bond at $2,500 cash or in the alternative of $5,000 surety. A requirement that he maintain contact with his parole officer, no leaving the state, no driving without a valid license and insurance. Remain law abiding, no drugs or alcohol without a prescription, and any other conditions that the court deems to be appropriate.
What's the file he should be on parole for?
It should be 09-2025 CR 2379.
2379.
Correct.
All right. Mr. Decker, you have the absolute right to remain silent. If you choose to remain silent, your silence will not be used against you. You have the right to give me a statement on bail if you wish. But again, anything you say can and will be used against you. These are recorded proceedings. The prosecutor can get a copy of the transcript and use any statements of fact that you make against you in these proceedings or in other proceedings. Do you understand the court's warning?
Yes, Your Honor.
Is there anything that you want to tell me about bail before I set it?
Yes, if I may. There are several factors including bail. One, I have a vehicle that's sitting on the road, and if I can't make the bail, that's gonna cost me money. 2, I don't have enough funds for bail. I'm from the Fargo area, I'm doing very well, I'm on parole, I work with the Ridge, recovery reentry center, all kinds of good stuff going on in my life. As far as ever not appearing for court, that doesn't seem to be ever an issue. And if it was ever on print, it's probably because I was in a jail, missed another court in another jail. And so that's never been an issue. I ran from a court hearing or afraid to go to a court hearing. That's not an issue. I'm doing so well in life right now, and the finances put into it are enormous. And to have this collapse under me is tough to do. And that if I can't afford the bail to get my vehicle to go back to work, I mean that's I can't. I mean I got everything I got going on financially out there. I mean, but I ain't in trouble as far as like a mess of society or, I'm doing really well. I'm really managed really well, Fargo. Really, those guys are awesome. And as far as like, I don't know what more I can tell you. Am I gonna not miss court? Obviously, I'm not gonna miss court. Do it, Can I afford a bail? No, I cannot. I have a vehicle on the road that's cost money. I got a job that's gonna cost me money. All this, but I don't have the money to do $500. Up here, I'm good. The ridge will get me there. For real. Those guys are getting me. So, I know it's time. As far as my budget worth money to secure coming to court versus my word, I apologize. The money's worth more than my word. But my word is obviously being bring to court. I haven't missed a word according to ever. I don't run. I don't need to. And I'm worried about losing the pile of stuff I have going on that's positive in my life. And I'm gonna end the shot anyway. That's why I was hoping just to get done and go and not lose everything. Versus dragging around $500 $500 is gonna cost me a lifetime of money. It's gonna cost me a life. You know, not literally, but what I built up, what I got going on today. With all the charges back behind me and where I'm at today and in a beautiful how I am, you know, that $500 is gonna collapse my whole world. If I just can't go and come back on a later date to court. It's gonna cost me everything, a lot.
All right.
Come see his mom, he didn't even go stop and see everyone. I mean, well, it's painful.
Mr. Decker, I'm going to set bail here in just a moment. I'm going to tell you right now, your next court date is October 6, 2026 at 1 p.m. Central Time in the Barnes County Courthouse in Valley City, North Dakota. That date, one more time, October 6, 2026 at 1 p.m. Central Time. To understand when you next need to be in court.
Sure.
I am going to remind you, and I've already made a finding that you waive the right to counsel, but I'm going to remind you, sir, that if you want counsel, it sounds like you probably would financially qualify for a public defender to help you. You can always decide to hire a lawyer, and you can always decide to apply for a public defender at a later time, but it's in your best interest so your lawyer can help you and make decisions with you and give you advice if you apply for a public defender sooner rather than later. Do you understand? You can always change your mind about the right to a public defender as long as your case is still pending.
Sooner, as in prior to this hearing, would have been optimal.
Yes, thank you.
All right. The court's considered the constitutional provisions concerning bail, including Article 1, Section 11 of the North Dakota State Constitution. The court's considered Rule 46, in particular Rule 46A, that has a presumption of release on one's recognizance or unsecured appearance bond unless the court has sufficient evidence before it to rebut the presumption of release on unsecured appearance bond to ensure the defendant appears. The state indicated Mr. Decker has some previous bail jumping and non-appearances. That posed the court some concern. Mr. Decker asserts that he has always made it to court. Court finds that the state's recitation of a bail jumping conviction is sufficient to rebut the presumption. The court's weighed the factors set forth in Rule 46A3 on release. The court finds the following bail to be appropriate and reasonable under the facts and circumstances of the case, including the nature and circumstances of the offense, the defendant's criminal history, the ties to the community, and the other factors the court is required to consider. The court has considered the declaration of probable cause. This was a search warrant case. I granted the search warrant based on the statements made by the trooper at the time. And so I know there's going to be a chemical test returned at some point. Courts again weighed those factors. The fact that the defendant has a rather lengthy criminal history, that he's currently on parole in file 09-2025 CR 2379, that he has a parole officer in that file, the fact that this is charged as a B misdemeanor level case, and it's a driving offense or what could arguably be construed as a victimless crime. I don't think that it is victimless. Society is the victim in this type of offense. The courts weighed the dangerousness to the community, risk of non-appearance, flight. And again, all those factors that are set forth in Rule 46A3. Court finds the following bail is sufficient but not greater than necessary to secure the defendant's appearance. And the court further finds that the non-monetary conditions that are imposed are tied to the Rule 46 release factors and appropriate to ensure the defendant appears when required. Bail will be set for the time being at $1,000 cash or an alternative $3,000 corporate surety. In addition, in addition to those monetary bail conditions, which
Oh, remember, in his ramblings, the man said that $500 would ruin me because he's got a broken down car over here and he's got rent over there. And he was only expecting to have to put up a $500 bail. What do you think's going on in that super speedy brain of his at the moment?
are imposed in the alternative at the defendant's option, the following additional conditions also will apply. The defendant shall remain law-abiding, not leave North Dakota without the advanced express permission of the court. Notify the court of any change of address, employment, phone number, or email within 24 hours of any such change. Not possess or use alcohol or controlled substances unless prescribed.
I'll take my son. I'm done.
Sit down.
You ruined my life. I don't need to live.
Mr. Decker,
It's
walk away from the court. Sit down or I will hold you in contempt.
Well, there's not about no. You ruined my fucking life.
Stop talking while
I
I'm
don't give a
finishing.
fuck what you're saying, sir. You can fuck off.
Sir,
Fuck
I'm
off.
holding you in contempt for conduct that occurred in the
Fuck off.
court's business.
$1,000, you ruined my life. You can fuck off.
Sir,
Fuck off.
I repeatedly warned you. You
I
are
said,
not.
fuck off. $1,000, you ruined my life.
Summary
You can
contempt.
fuck off, Judge.
I'm
$1,000.
imposing a
my fuck-
$500 fine as a summary contempt. Sit down. Mr. Decker is flipping me off. The jail has muted the microphone. He has walked away from the court several times. Conditions are as follows: remain law-abiding, not leave North Dakota without the advance express permission of the court. Notify the court of any change of address, employment, phone number, or email within 24 hours of any such change. Not possess or use alcohol or controlled substances unless prescribed. Sign a promise to appear in waiver of extradition before release. Comply with all currently imposed parole and or probation conditions in file 09-2025 CR 2379, which are incorporated by reference into the court's bond order. Meet with Mr. Decker's parole and probation officer within 72 hours of release. Have minimum weekly contact with the parole and probation office. Personally appear for all scheduled court hearings. Your next court date, sir, October 6, 2026 at 1 p.m. Central Time, Barnes County Courthouse in Valley City, North Dakota. Submit fingerprints before release. Not drive or operate a motor vehicle without a valid license or permit to do so, and valid liability insurance as required by North Dakota law.
The judge gave him that October 6th date before he mentioned bond, because I think the judge anticipated this was going to be the reaction. And he didn't want that guy to have any excuse for his failure to appear, that if he does make bond, we can expect, because he's got a lengthy history of bail jumping and failures to appear, as his criminal record showed. So now the judge can say that he was advised prior to any mental trauma that he may have sustained from hearing his bail amount.
Again, the court has imposed a $500 fine for the defendant's willful and intentional contempt of court, for swearing and cursing at the court after being given warnings to do so, getting up during the proceedings, interrupting the court's proceedings in the court's presence, and obstructing the court's process and abusing the dignity of the court. As such, the court imposed a $500 contempt finding. And I'm doing so under the court's authority, under the statute, which I will read in just a moment. Under North Dakota Century Code, Chapter 2710, 01.2, the court may impose a remedial or punitive sanction for contempt of court under this chapter. Contempt as defined by Century Code Section 2710.01.1, Sub 1, Sub A includes intentional misconduct in the presence of the court which interferes with the court proceeding or with the administration of justice or which impairs the respect due the court. A punitive sanction includes a sanction of imprisonment if the sentence is for a definite period of time. A sanction requiring a payment of a sum of money is punitive if the sanction is not conditioned upon performance or non-performance of an act, and the sanction's purpose is to uphold the authority of the court. Here, the court finds Mr. Decker's behavior constitutes intentional misconduct in the presence of the court. The court finds that Mr. Decker's conduct interfered with the court proceeding or with the administration of justice and impairs due respect to the court. The court imposed a $500 sanction, which the court intends to be punitive in nature. And again, it is not conditioned upon the performance or non-performance of an act. The court finds beyond a reasonable doubt that that offense or that conduct occurred. And again, the sanction's purpose is to uphold the authority and dignity of the court. An order of contempt will issue in writing. Ms. Duffy, do you have any questions about the court's order?
No, Your Honor.
Do you have any questions about any other portion of today's proceedings?
No, Your Honor.
I'll have the jail unmute Mr. Decker.
I have a right to remain silent. I choose to do so.
Stop talking until I ask you a question.
I understand the clerk's saying I have a right to remain silent. I have nothing to
Mr.
say.
Decker, do you understand the court's bail order?
I say nothing to you.
Mr. Decker, I asked you a question. Do you understand the court's bail order?
Yeah, I said fuck off. I said nothing to you.
Mr. Decker, if you continue to swear in court, I will hold you in contempt again.
Oh, and then what?
I'd prefer that you don't do that.
Okay, go ask some questions. I said fuck off. I ain't saying nothing.
Sir, you are
Yeah.
a breath.
$1,000 because you ruined my life for $1,000. Fuck off, Judge. I got nothing. I got no respect for you. Earned it.
Again, sir,
Fuck off. I said.
I'm holding you in contempt again.
Again, you're a
Imposing
powerful diaper.
$50. It is punitive.
Diaper powerful. Fuck off.
All right, we're done.
$1,000, you punk bitch. Fuck off.
Issue a written
You sound like that, you piece of shit.
done. Have a nice day. We're off the record.
Charles. Thurston County District Court is now in session. Judge Wilcox presiding. Thanks. And Mr. Taylor, have a seat. We're on record here at Thurston County District Court for the afternoon calendar, City of Lacey and City of Olympia and custody matters. Let me try and get this to work here. Come on. All right, in the Nisqually booth, your name, sir? the Nisqually booth in the jail. What's your name?
Frederick Austin.
Frederick Austin? Okay, Mr. Austin. And so it's Frederick Michael Austin,
Yes, ma'am.
and date of birth is what?
10/15/1990.
Okay, I'm gonna turn Mr. Who
Your Honor,
worked with,
Your Honor,
Mr.
the family contacted me last night and retained me as an attorney.
okay, have you had a chance to get information from the city of Lacey yet to be prepared for this arraignment?
Yes, Your Honor.
Great, okay, so I'll turn to you then.
Your Honor, this is, the charges are 3 domestic violence charges. The victim's on the line. I've exchanged text messages with her. She has no problems with Frederick being released on a PR status. He's employed heating HVAC technician. He's 100% disabled.
Before we get there, so
Oh,
I
sure,
take it
sorry.
you're in a plea of not guilty. Do you stipulate to probable cause for the
We do,
setting
Your
and
Honor.
release conditions? Okay.
Yes, thank
And
you.
then we can kind of inquire of the city what they're thinking, and then I'll turn back to you. And if
Okay.
Ms. Morgan wants to be heard from, we can hear from her as well. But at this stage, Mr. Austin, you're charged with those 3 crimes: an allegation of simple assault, domestic violence, harassment, domestic violence, malicious mischief, domestic violence. And I'm entering pleas of not guilty to all of those. That keeps all your rights in play. And then what happens next is I'm going to hear from the prosecuting attorney what their opinion is about what release conditions, if any, I should set, conditions on your behavior until you resolve this case. I'm going to hear from Mr. Woodrow on your behalf and make that decision. So first off, Ms. Eddy.
Yes, good afternoon, Your Honor. The city is asking for bail to be set at $5,000 with conditions of no law violations, no firearms or deadly weapons, and no contact with the victim. Just to give the court kind of a brief overview of what this case was about. So it was reported back on June 20th, and the victim I believe is married to the defendant. The victim was out at a friend's house. When she got home, the defendant was upset, and the victim got some of her. The victim was walking towards the door of the home, and the defendant threw a car seat at her with enough force that it broke when it hit the front of the house. The officers reviewed a ring camera of the incident, and they could see that the defendant came up behind the victim and violently threw the car seat towards her. She appeared to be visually shaken and rushed inside. The officers heard on the audio recording, and I quote, the defendant said, I quote, "fucking bitch, I'm going to fuck you up," as he tried to get into the house. The victim said that their 4 children were there during the incident, and that he had strangled her on multiple occasions, and that she believed that had he been able to get into the home, he would have assaulted her, and that he intended to hit her when he threw the car seat. It took law enforcement some time to locate him, and that's why he wasn't arrested at that time. The city of Lacey, I believe, had prior charges against him, although apparently it was under a different name, the Ricky Michael Washington. He also has another alias, Frederick Michael Cherry, that I believe is associated with him. So the city is asking for a no contact order today. I understand the victim is on Zoom and does intend to ask for a no contact order, but it's the city's position that that at this time that's not safe, and we are asking for one.
She slightly misspoke there. She said the victim is going to ask for a no contact order, but the city feels that's not safe, and so they're going to ask for one. Needless to say, the victim is going to make every excuse for him. And one other thing that I did want to point out, they said that the car seat that was thrown hit the house and broke part of the house. And I need you to remember that statement.
Mr. Woodrow, on behalf of your client.
Thank you, Art. So I reviewed that video that was taken with the Ring camera, and I didn't really hear a lot of distinct words, but it wasn't a baby carrier. It was the inside of the baby carrier, the kind of cloth part that goes inside of the baby carrier. He did throw it. It's on the camera. It hit the young lady in the back, but they were probably 25, 30 feet apart. She locked the front door. He went over there. He didn't bang on the door or try and get in. He simply picked up the cloth container or inside of the baby carrier and put it down on the porch. He then picked up another little item, put it on top of there, turned around, walked away. So that's what I view when I looked at this video. He was upset, and this has been going on. I mean, this happened a while ago. He hasn't tried to have contact with her. He hasn't tried to call her, talk with her, threaten her in any way whatsoever. He does have a good job, works for HVAC, makes good money. He's 100% disabled from the military. So if he stays in custody, he might lose his job. He has to pay mortgage and, of course, support his family. And I did talk with Frederick about the no contact order. He's more than willing to abide by that. And even if it includes that he can't see his children for a period of time, he's okay with that as well, Your Honor. Thank you.
And Ms. Morgan, I see you're here on the Zoom platform. You don't have to say anything. If you don't want to, you can just watch what's going on. But if there's something you want to say about this request on release conditions, then I'll hear from you today. Ms. Morgan?
Hi, thank you for allowing me to speak. I do want to make a correction that the car seat did not hit me, it hit the house. And I
want to ask you about is not the facts here. We're not having a trial. What I'm being asked to do here is potentially issue an order that disallows Mr. Austin from contacting you. That it says here, the thought is that he should stay 1,000 feet away from you, wherever you live, whether you're there or not, school, workplace, wherever you are, and not contact you in any way, shape, or form. Do you have any comment on that condition?
I would prefer that that would not be put in place. I don't feel like my life is at risk if he were to contact me or be able to, for us to be able to co-parent our 4 kids.
And you have 4 kids. How old are the kids?
Well, I have a daughter who is 15, and then we have 3 children together, and they are 12, 5, and 4.
Okay, all right. So the 15-year-old, maybe the 12-year-old can contact Mr. Austin on their own?
Yeah.
Okay, that's fair. The other 2 maybe not. All right, and so you're asking that I not issue this order. All right, so I am going to issue an order today. You're objecting to it, and that's fine. We've issued orders before, it was quite some time ago, to protect the folks in this relationship. And going back to 2013, yeah. And it restrained Mr. Austin at that point from contacting you. And what I'm trying to do is make sure that everybody stays safe and that no one's put in danger any longer. And right now, I think an order needs to be issued to ensure that, at least for now. These are not forever, and they're reviewed as we go, but for now. So, Mr. Woodrow, I'm going to allow what we call that civil standby. Mr. Austin's allowed to contact Lacey Police Department and get an escort back to the Hannah Drive to get some personal belongings if he needs them. And then Lacey would stay with you. They would then escort you away. You don't go back to Hannah Drive without law enforcement escort, but that's the one exception there. Obviously, this is as to Takia Morgan. Now, if your 2 kids who are old enough, the 15 and 12-year-old, want to contact you on their own, that's up to them. Contacting them is not contacting Ms. Morgan, but you're not to pass messages through to them. You're not to use them as a conduit to contact, because that would be a violation of this order and potentially end you up back in jail, charged with new crimes. And you've heard that this is the court's order over the objection of Ms. Morgan. Ms. Morgan can't change it. It only changes when you're in front of a judge that changes it. And so even if she were to invite you to violate this order, Mr. Austin, you could be arrested even on her invitation, put back in custody, maybe charged with new crimes. So you've got an attorney now, Mr. Woodrow. Talk to him very particularly if you have questions about this order, about further court orders. But I'm going to release you from custody, because I think that by issuing this order, ordering that you surrender all firearms that you may have in possession and not possess any going forward, don't violate the law, that is going to be the least restrictive alternative. But as long as you follow these orders, then you'll stay out of custody as you see to the end of this matter. We're going to set a court date, Mr. Woodrow here. Look to you, Amy. What day should we set? August 3rd, 9 o'clock in the morning. You'll be back. Mr. Woodrow, that work? You're not on vacation or something?
I have a Superior Court matter at 9 o'clock. And we put it
Okay.
after that, 10 o'clock?
How about the 10th of August?
Oh, the 10th is awesome. Thank you, Honor.
Okay, we'll do the August 10th at 9. We're on a 90-day clock here. And then later today, Mr. Austin, you'll be released and you'll have copies of your new court date, copies of my order, copies of this no contact order. And again, talk to Mr. Woodrow if you have questions about it. All right?
Thank you.
All right, you're welcome. And anything else, Mr. Woodrow?
No, Your Honor, that's all. Thank you. Appreciate it.
That's all then. And Mr. Austin, you can knock on the door and they'll let you out of the booth. So Ms. Lamari, are you ready to take Sarah Brown's matter?
Yes, Your Honor. Is she present in the courtroom?
No, if you notice on Zoom, she's out of custody. She posted bond.
I knew everyone would want to know what Sarah's case was all about, so I left it in. Whether it is, interesting or not, I left it in.
Oh, I didn't see her there.
Yeah. So,
yes, Your Honor.
I need you to get your camera going.
Sorry. Thought it was.
There we go. All right. So Ms. Brown, I'm just wondering if Ms. Brown can hear us. Ms. Brown?
Yeah.
Okay, we got Ms. Brown. So Ms. Lamari?
Yes, Your Honor. So I did go to the jail to visit her and then found out that she had bailed out, so we missed each other. So what I would ask to do, since our dates, the dates on this are
dates. Yeah. Let's talk about those. We've set September 3rd for confirmation, September 16 and 17 for trial within that 90-day clock.
okay. I think that's fine then to just leave those set. I wasn't sure if it'd been set within the 60 or not. And then if she could update the court with her information, that would be helpful.
So Ms. Brown, do you have a mailing address yet? Ms. Brown, if you can keep the phone on you as opposed to on the ceiling.
Yes, ma'am. I would ask my friend the address. It's PO Box.
Yes.
PO Box, Bucota, Washington, 98530.
So it's PO Box Bucota, and what's the zip?
98530.
98530? I don't know if that's right. All right. And then do you have a cell phone we could send you a text message reminder to? Ms. Brown?
Yeah.
Okay. What's that?
360.
360. And also,
one more time? That's okay.
360. 36 because he's going to come. 846.
We got it now. Okay.
And then my home number My home number is 2.
So we just need a number we can send a text message reminder to that will get to you. Which number should we use?
The either one.
All right,
Uh,
we'll use that first one, if that works for you, if that'll get a message to you.
Yes.
Okay, yeah. Please do text me. Oh wait, no. Oh shit. Oh shit. Yeah.
So Ms. Brown, are those address and phone number good to get a hold of you?
Yes, ma'am.
Okay, so we're gonna see you September 3rd at 10 o'clock in the morning. And you're working with Ms. Lamari, and you've got that information, Ms. Lamari, you can contact your client then?
Yes.
Yes, Your Honor, I wrote down
Good.
those phone numbers. And then, Miss Brown, you can always call the court or if you don't have my information.
Ms. Brown?
Yes, ma'am. Okay,
So
yes,
that was
ma'am.
your talking, Ms. Lamari, she's gonna be contacting you. You need to be in touch with her and then back in court on September 3rd, all right?
Look at her hands. Those are burns or resin or residue from tinfoil or bubble. Or she's just really, really nasty, dirty.
Okay, yes, ma'am. Yes, ma'am. September 3rd.
September 3rd at 10 o'clock, you're back in the district court.
Sorry, I've been having seizures. My head's hurting. It's hard. It's a little hard to.
Well, you got a friend there. We're gonna mail you notice. We're gonna send that text message reminder and that'll help.
Yeah, I got you.
Okay, all right. Thank you.
You're welcome. You can be off now. Thanks.
Oh, she's off.
Thank you, Sheriff.
And thanks for helping.
Yes.
You can be on your way.
Yep. trying
And
to get
then
here.
in the Nisqually jail booth, who's there? All right, in the Nisqually Lacey calendar in the dark hair. You're sitting to the side, in the Lacey booth. What's your name? Anyone know who this is?
Your Honor, I believe this is Miss Hunter, Yvonne Hunter.
Do I have Yvonne Hunter with it? Are you there?
Yeah.
Okay, Miss Hunter, all right. And over here, there's an allegation, a charge against you, a simple assault, domestic violence. That's what we're talking about. So it's your full name, Yvonne M. Hunter.
Yes.
What's your date of birth?
6/10/79.
Okay, I'm going to turn to Ms. Ruiz.
Thank you, Your Honor. I have advised her of her rights and I do believe she understands them. We waive formal reading of the complaint, stipulate to probable cause for the purpose of this hearing only, and enter a plea of not guilty. And I do believe she qualifies for appointment. She currently does not have any income.
Okay. So Ms. Hunter, as to that allegation of simple assault, domestic violence, I'm going to enter a plea of not guilty. Keeps all your rights in play. I'm going to set another court date, give you that court date today. And first I'm going to hear from the attorneys. I'll hear from the prosecutor first, what they think I should do about release conditions, which are possible restrictions on your behavior until we resolve the case. Then I'm going to hear from Ms. Ruiz about her opinion and I'll set those conditions. So first off, Ms. Eddy, on behalf of the city.
Yes, Your Honor, the city doesn't oppose Ms. Hunter being released on her own recognizance. From what I understand, she was in Alaska and had only I don't know if she was visiting or just moved here a week ago to stay with the victim. But the victim does not want her at his residence, and he does not want any contact, so he would like a no contact order. I note that Ms. Hunter was intoxicated in this case, both as reported by the victim and as observed by law enforcement. And she does have several Alaska convictions. It looks like the two most recent, although they were over 10 years ago. In 2008, she was convicted of operating under the influence. And in 2011, she had an enticement in intending to commit crime, where I could see that she was ordered to do some alcohol-related conditions. So we would ask for conditions of no law violations, no contact with the victim, that the court issue the domestic violence no contact order, no firearms or deadly weapons, and no alcohol or controlled substances without a prescription, and no bars or taverns.
Ms. Ruiz, on behalf of Ms. Hunter.
Yes, thank you, Your Honor. We're requesting that she be released on her personal recognizance. She does not have any criminal history in Washington, and as mentioned by Miss Eddy, that out-of-state history is 15 years old and older.
She didn't say 15, but I love the framing of she doesn't have any criminal history in Washington. Never mind the other states. Just she's not committed crimes in the month that she's been in Washington.
And we would request a no hostile contact order as opposed to a full no contact order. They've been together since 2019 with no history of violence, and she came down here from Alaska just this past week to move in with him. She would have trouble finding housing otherwise. She believes she has family in the area, but has not been in contact with them recently and is unaware of where they live. And so she is unsure of where she would be able to stay or pursue contact if she were unable to return to the residence. She is able to take public transportation and is willing to comply with any other court orders. Thank you.
And excuse me, Ms. Eddy, the address for a civil standby, and Ms. Ruiz, I have both in Lacey, and then is this in Lacey or Aberdeen on 12th Avenue?
Let me double check the police report, Your Honor.
I think someone entered it incorrectly as Aberdeen as opposed to Lacey.
It should be,
look at that.
it should be a Lacey address.
So 98503, all right. Okay. All right, you ready? So Ms. Hunter, you will be released from custody later today. Not going to hold you in custody, but I'm going to put some conditions on your behavior. And if you violate those, then you end up back in jail. And that's what I'm trying to prevent. Part of this is, for now, you're not going to have contact with Jason Brown in any way, shape, or form. I will allow you to contact the Lacey Police Department, and they can escort you back to that address on 12th Ave and get some personal belongings. They'd stay there while you get those personal belongings, and then they'd escort you away. You don't go back to that address where Mr. Brown lives at any point without law enforcement escort. And you don't contact him in any way. You don't contact them through family, through friends, through social media. You stay 1,000 feet away from wherever he lives, works, goes to school, wherever you know he is. You stay 1,000 feet away. And then you come back to court. So you follow that order. You don't violate the law in any other way. Don't possess any firearms and surrender any that you may have. And come back to court, and then you'll stay out of custody if you follow those conditions. I'm writing it all down for you, and I'm going to set that court date today. What's that date? August 4th. So August 4th at 10 in the morning, you're back in the district court, and you have an attorney from, let's see, appoint Ms. Langley to represent you. Actually, we need to do that August 3rd. I should have done that. I'm sorry. So it'll actually be August 3rd, and I'm writing it down. You'll have Ms. Langley to represent you after today. And we'll tell her that you are her new client, and the facility there can give you her number, and city, you can always contact the court for that information. Now,
And Your Honor, I'm sorry, Miss Langley, she sent us an email with her leave dates. Does the court taking that into consideration, or do I need to dig up the email with her leave
do
on
you
it?
have that, Andy? That would be helpful.
Yeah, give me
I
just a
did, I
moment.
don't have it in front of me. Thanks.
It might have been August 3rd.
As well, for now, Miss Hunter, you stay clean and sober and stay out of bars or taverns to make sure that you don't have any further criminal behavior based on the use of substances, given the history in Alaska and now here.
Okay. So I have a question.
Sure.
So all the information will be on, my paperwork for where
Yes,
to go to court and stuff?
Yeah, your new court date and exactly that, the conditions here. Let me put Miss Langley's phone number right on that too, since I've got it.
Just imagine this little snippet at the end of this woman's case. My goodness. When I copy and pasted our friend there around, I seem to have missed a little section. And by the way, like, tell me how it is that this Nisqually Lacey chick, tell me how she looks like an elderly woman and a baby with gas at the same time. I don't know how that worked out that way, but she really does.
And I did check Miss Langley's vacation starts the 4th, so she should be available on the 3rd.
We said it the week before. I'm gonna set it the week before, July 27th. So the end of this month, July 27th, 10 o'clock in the morning, you're back in, and I've written that down. I'm putting Ms. Langley's phone number on this as well. So you'll have that. And I would suggest you give her a call before and make an appointment to talk. At very least, you'll meet and see each other at the next hearing.
Okay.
All right. All right. Any other question there?
No.
All right. That's it for today. You can knock on the door and they'll let you out of the booth.
Okay, thank you.
You're welcome. And in the Nisqually jail there, your name?
Summer Mumford.
I don't, I'm sorry, the last name again?
Shamra Mumford.
Mumford, thank you. All right, Miss Mumford. All right, so Miss Mumford, you missed your court appointment on June 16th, so we issued a warrant. So that's what we're talking about here, about cases still pending trial, the criminal trespass 2 and allegation of possession of controlled substance. So I'm going to turn to Ms. Ruiz from Pacific Point Defense.
Yes, thank you, Your Honor. We're requesting that the warrants be quashed and she be released on her personal recognizance. She missed because she's been struggling to get access to her prescribed medications to help provide her more stability. She's also unhoused right now and doesn't have a phone, so she wasn't able to get into contact with our office. I did let her know that if she were released, we could get paperwork to her that has ways to contact our office and see if we're able to connect her with any resources. These allegations are nonviolent and her criminal history is fairly old, so we request that she be released. Thank you.
All right, and City of Lacey, anything to add?
Well, Your Honor, I'd note that Ms. Mumford failed to appear at her first arraignment on the criminal trespass case when I believe she was cited and released. Then she was arrested later for the second case, the possession of a controlled substance, and released again. Then she failed to appear after that. So she's failed to appear 2 times already. So The city is asking for bail at $100 in each case for a total of $200 to secure her future appearance.
The only time
So how are we gonna get your client to court, Ms. Ruiz? What's the assistance that someone's gonna be able to have to get her to court? It's been twice now. We hand her notice, doesn't show up. What do we do?
Your Honor, I'm hoping to connect her with our like social services liaison and hopefully try to get her connections, and if she's able to visit our office instead, since she doesn't have a phone, try to get her to come visit our office so we can continue working on her case with her.
And your office is up in Tacoma?
Yes, Your Honor.
All right, Ms. Mumford, where do you find a place to sleep usually? Are you here in Thurston County or where do you go?
Yeah, this is where I'm finding some kind of confusion. Okay, the last time I just got out of here, I was supposed to have a court date, and my next court date was supposed to be on the 9th, right?
No, the 16th.
No, the 16th was the court date that I missed. The 9th.
Yeah, the one you missed.
Okay,
Yeah.
so the 9th is they're saying that the next court date that I'm supposed to be having is the controlled substance, and I never got there yet. Okay, so that's what I'm saying. The controlled substance.
So I'm wondering, are you usually in Thurston County or in around
Yeah,
Lacey or Olympia? Where?
I'm sorry for interrupting you. I live in Thurston County, but my scene with
Okay.
this whole situation is that now they're saying that the next case that I was called in to get seen for was the possession of this controlled substance. But now I just got picked up on a controlled substance, but the controlled substance was with my Suboxone, and I have to have something so that I can stay awake, so I'm not outside with guys.
Miss Mumford, I don't want you to talk about any of the facts of the case. If you can just kind of tell her about, where you're staying and your ability to make it to court.
Well, the only reason I just said something to her now is because she's saying that the prosecuting attorney is saying that I've now missed 2 court dates. I've only missed 1.
So
Okay, so
we
she's
had
saying
an
that
address once on the Spartan Court. Is that no longer any good?
This is my scene. Okay, so that's my house. That's my house.
Okay.
He did some prank and they put a porn hub in my house and moved me out because I got raped in there. And so now they're saying I don't live at my house, and that's why I'm homeless.
All right.
Okay, so
And
I
so
gotta
when
make-
you're
I'm
trying to
making-
stay around Olympia, Lacey, somewhere in Thurston County, find places to be, all right?
And seeing what the hell is really going on, and now I'm seeing it's all hooked up. Like everywhere I end up, it's hooked up where I'm going. And so if it's all hooked up where I'm going, it's all going into my house has never been like that. I've never had anything like that completely at all go down in my house. I had a minister father, and my mom was a first sergeant in the military. There was nothing like that ever going on anywhere in my house, And it's kind of awkward that it's completely, it's mayhem, and I don't understand any of it. But I know that it's not supposed to be on me. And I want to know why it keeps.
So, I'm gonna set a court date in a week, July 9th, 1:30 calendar. You're gonna be back in court on the 9th at 1:30. I'm gonna have you post bond. I'm gonna keep it at 500 cash or bond on each matter as you don't show up when we need you to show up. But we've got Pacific Point Defense appointed. We're gonna be back next week on Thursday. I expect that the attorneys will be talking with you soon, and we'll have that court date then for a pretrial, and it sounds like there's a few things to suss out for you. Maybe if there's a more stable place to send you, we can release you, but right now you just don't come back and we don't seem to have any stability.
It's not even that I don't come back. My knee is fractured, and that's why I'm not even supposed to be in here right now. I'm supposed to be going to the doctor, and I can't go.
Okay.
I have 5 hairline fracture on my knee and cannot really move.
Talk to the facility there. They've got medical staff. So
Yeah, I know, but
that's
they
an
won't even let me.
important thing to let them know.
They won't even let me have my ace bandage on my leg.
So, Ms. Ruiz, if you can let your office know, we're back next Thursday. And there's a few things that maybe can be helped out from Ms. Mumford, but right now, everything's still pending trial.
Yes,
We're
will do.
back
Thank
on
you, Your Honor.
a 60-day clock on both of these.
So I have to stay here instead of,
Right, I'm gonna have you postponed until you come back.
I don't have anyone to call. Everyone I know is dead, and my kid's birthday's coming up. My leg's I can't even talk to anybody. This is doing better. And the people that are doing this here, fucking, yes, this fucking place anymore.
Your attorney will be down there to talk to you soon. There's a lot of things to unwind. So turning to the other booth in Nisqually, you've been waiting there. What's your name?
I believe that's
Ms.
Miss
Joe?
Alethea Folk. Miss Folk. Oh, looks like she's muted.
Ms. Folk?
Oh,
I think we need to get Ms. Folk unmuted, that other booth, if corrections is hearing us.
And Your Honor, I believe that was Lacey's last matter. If we could be excused, please.
If it is, so
right.
long. Have a good long weekend.
Thank you. Happy 4th of July to
Thank you, Your
everyone.
Honor.
Okay, thanks. You too. So we got to get the Nisqually booth unmuted so we can talk with Ms. Folk.
oh, there we go.
All right, Ms. Folk, you're here, and looks like we just need to continue on. Ms. Cho, Mr. Carvey, you had a chance, both of you, to review what the evaluation said.
Yes, Your Honor. My understanding is that the evaluation has deemed her to be competent, and I did have a chance to review 2 pleas with Ms. Folk this afternoon, and those have been submitted to the court. Is the court in receipt of those?
I do have those. Okay, I'll go through those.
Thank you.
All right, whatever, at least we got it. All right, so Ms. Folk, looks like you're pleading guilty to that theft in the 3rd degree from May 22nd and the indecent exposure from June 9th. Feel you had enough time with your attorney to make this decision to plead guilty?
Yes, ma'am.
Okay. In each of these are all of your rights to have a trial. Do you understand those rights?
Yes, I do, ma'am.
Okay, and you know that if you plead guilty, you give up those rights to have a trial in these cases?
Yes, ma'am.
Okay, and that's your choice.
Mm-hmm.
Good. All right. And then I see there's a recommendation as to how the court should sentence you. Looks like the recommendation from the lawyers is to accept your plea on that theft and then close the case altogether. On the indecent exposure, asking the court to impose no further jail time, release you, and just tell you, don't violate the law, but put you on probation for a mental health evaluation. Do you understand what the lawyers are asking me to do?
Yes, ma'am.
You know, I don't have to go along with it.
What was that?
You know, I don't have to go along with the lawyer's recommendation
For probation?
for anything. I can impose whatever sentence I feel appropriate within the law. You know that?
Yes, ma'am.
Okay. All right. And the indecent exposure carries a maximum of 364 days in jail and a $5,000 fine. And the theft carries a maximum of the same. Do you understand that?
Yes.
Okay. Now I've asked you to make a written statement in each of these cases of what you've done wrong that makes you guilty. And you're saying here, let's get to that. So on the theft on May 22nd of this year, you still with me? That you took items from the Thriftway with the intent to deprive Thriftway of them, and that was in Olympia. Do you accept that as what you did wrong?
Yes, ma'am.
Okay, and then you're saying on June 9th, you said your private parts were exposed in public and a member of the public was offended, and this also occurred in Olympia. Do you accept
Yes.
that?
Yes, I do. Yeah.
So has anyone threatened you with harm or made you any promises that have caused you to plead guilty?
No, ma'am.
Okay, all right. Well, how do you plead to one count of theft in the 3rd degree?
Guilty.
And how do you plead to the indecent exposure?
Guilty.
Okay. Well, Ms. Folk, I will accept your pleas, and I'm doing that finding you know what you're doing. And you're doing this voluntarily and intelligently and doing this understanding the consequences of pleading guilty. So I find that statement as well supports this. And then we'll move on to sentencing. So I'll hear from the lawyers and I'll turn to you if there's anything you want to say. But first off, Mr. Carver, on behalf of the city.
Thank you, Your Honor. It's an agreed recommendation. I ask the court to follow that recommendation. Flagged in some of the mental health assessment, 1077 assessment that she did, flagged some issues for mental health evaluation. So we think that her participation in that will prevent some recidivist behavior.
Ms. Cho?
Your Honor, we just ask that you follow the recommendation and do believe that the recommendation, as Mr. Carver indicated, will hopefully address any underlying issues. And we believe that the recommendation is appropriate.
Does your client have any relationship or options for treatment that you know of?
I'm not sure, Your Honor.
Okay. Well, Ms. Volk, anything you'd like to add to all this?
Yes, I'm certainly sorry. I'm on DOC. I don't know why this is actually happening to me. It's been a very frequent current thing that's been most recent and present. And this day and age, I keep getting locked up for new charges. And I'm really disappointed that my DOC officer and my DOC sanction officer are not making money right now, because that's how you can make top dollar right now. So I don't know why they're charging me new charges. It's not allowed to happen while I'm on DOC, but it's still going on. And I apologize on the 2 new charges. It is very, very hard going through homelessness. And other than I keep myself clean, and I will take these and be guilty and serve the justice system and apologize for everything that has happened. I'm really not that bad of a person. I didn't mean to actually do that with the government and everything going on with the business.
Okay, well, thanks for the apology on behalf of the community. That's important. And just kind of looking at what we've done before together here. So, Ms. Volk, I'm going to go along with that recommendation on the theft and just accept that plea. It goes on your record, and that case is closed. You don't have any obligations under to the court.
Yeah, clearly, my cat helped me edit this. I am so sorry for the out of order synchronage.
On the indecent exposure, all I'm going to say is for the next year, you stay out of trouble. So you serve.
Yes, ma'am.
All right. So don't violate the law in any way. Not going to put you on probation. It has been real successful in the past. And then my hope is that we don't have to impose any more jail time on this indecent exposure if you violate the law in the meantime. All right.
Okay.
Okay. So you're going to be released later, and just don't violate the law. And that's it for today. You have any questions?
No, thank you. It's been a great day, and thank you for being here, showing up.
Well, thanks. You're welcome.
For me.
So you can knock on the door and they'll let you out of the booth.
Thank you. Have a great day.
You too. So, doesn't look like it. Oh, there they are. Okay, thanks.
She was found competent.
Just one of it. The other one should have one of them I was able to.
Mr. Truce, I'm going to call your next client. I believe that's Richard Johnson. So let me find that file. State of Michigan versus Richard Johnson, 26-44365-FY, set for sentencing. I do see Mr. Johnson's with us. Mr.
Yes,
Truce.
sir.
Thank you, Your Honor. Richard Truce appearing on behalf of Mr. Johnson. This is the date and time set for sentencing on this matter. We sent over to the court yesterday a support letter from Mr. Johnson's employer, as well as I think we sent the substance abuse assessment. I don't remember if that was yesterday or earlier in the week, but that should be there as well.
Thank you. I have received the letter on behalf of your clients from Will Horsell, owner of Sawicki Builders. It's approximately a paragraph long, so I have reviewed that, and I have reviewed the Catholic Human Services Substance Use Assessment Report for your client that was submitted by Charles Heidema from CHS. Mr. Johnson, I'm going to give the lawyers both an opportunity to make recommendations to me about what they think I should do for sentencing. Once you've heard that from them, I'm going to give you an opportunity to tell me anything else you want me to know before I decide what to do. Ms. Brucker, your comments?
Judge, I've seen the employment letter. I don't see the substance abuse assessment, and I'd like to just take a quick look at it before I allocute.
Mr. Truce, do you have that in email form that you can send to Ms. Brucker?
I do, and I apologize. I think I sent it directly to Mr. Fortier because I assumed that he would be handling the matter.
So, Mr. Truce, while we're waiting for her to review that, why don't you go ahead and allocute, and then I'll give her a chance, but I'll come back to you if there's anything that you want to respond to what she says, just so that you have that ability at the end. But if you go ahead and allocute now while she's reviewing that.
Thank you, Your Honor. In regards to Mr. Johnson, I think a statement that Mr. Fortier made, I think all the way back at the arraignment, probably sums this up about it as well as I can. And Mr. Fortier had made a statement to the effect of, I don't think Mr. Johnson is a bad person at all. I think he's someone who struggles with substances. And that's been my experience with Mr. Johnson. I think he is a hard worker. I think that he has struggled in his life with substances, and he's in a place right now where he's doing pretty well. He has a very good job. He is managing his sobriety pretty well. He's been working with Bear River, and he's been maintaining his sobriety well. My view here is the court could take two different types of actions here. The court could take a punitive action and look at putting Mr. Johnson in jail. I don't think that's the right action here. And I say that because I think what that does is it probably sets Mr. Johnson back. Putting him in jail likely causes him to lose his job. It likely causes him to have a negative effect on his house. And those are exactly the type of stressors, I think, that can cause him to go back down the road that none of us want to see him go back down. I think that a better way to address these types of cases is to encourage people to take the right actions. And right now what we have is Mr. Johnson's on the right path. He's got himself a good job, stable housing, and he is engaged in the recovery community. I don't think we want to disrupt that. I think what we want to do is encourage him to continue that path and hold his feet to the fire. I would suggest in this matter that it would be appropriate to hold jail in abeyance and give him an opportunity to show the court that he can maintain his sobriety. He is in a good place right now. I would hate to see him set back. This is a nonviolent offense, which I think is clearly indicative of use and addiction, not indicative of anything like delivery or anything more nefarious than that. And frankly, I think if you look back at Mr. Johnson's history, you'll see consistently that. You'll see convictions that are indicative of addiction and substance use, and nothing more nefarious than that. So again, in that circumstance, I think it is appropriate to craft a sentence that, again, encourages him to continue the good path that he's on while holding consequences and holding him accountable if he steps off that path. Thank you.
Ms. Brucker, your comments?
Just briefly, and I can't tell from this assessment what he's done since he's done the assessment or prior to that. I did note in the recommendations that they're recommending he enroll in an inpatient substance abuse treatment program and have a further mental health evaluation. So I don't know whether that's something he's already done in the past, Richard, or not, but at any rate, that seems to indicate he has a pretty severe issue. He does have a pretty serious past history with controlled substances, though. Back in 2024, he did do some treatment that obviously was not successful because we're back here with the court again today. So I agree with a lot of what Mr. Truce says, but I also think there should be some consequence as well. I suggested the court to perhaps maybe just order some work camp that would allow him to continue to work and to do his other programming as part of the probation, but would also give him a bit of consequence. Like I said, he does have that criminal history. He's been through the system before. This is not his first time. And I'd ask that the court order that he follow the recommendations in the substance abuse assessment.
All right. Just so everybody's clear, and I'm going to give Mr. Truce an opportunity to comment if he wishes afterwards, but the criminal history as I see it, it's on the records before me, indicate that in 2007, he was convicted for possession of a narcotic less than 25 grams, did about 28 days of jail for that. In 2015, convicted for domestic violence. 2016, convicted for domestic violence, second offense. Looks like he did a year in jail for that. 2019, misdemeanor larceny between 200 and 1,000, year in jail for that. Actually, there were 2 counts for larceny offenses on that conviction. 2021 in circuit court here in Otsego County, excuse me, in Crawford County, pled guilty to possession of methamphetamine. I don't see the, it looks like 3 years of probation and a year in jail. 2021 in October, conviction for assault with intent to do great bodily harm, went to prison for 5 months to 5 years. I don't see that as a small amount of criminal history. Mr. Truce, is there anything else that you would want to add now that you've heard my view of the criminal history and the comments of Ms. Brucker?
Just 2 things to add, Your Honor, and I don't say this to belittle the criminal history here. I mean, certainly he has some history. I think he would tell you that the history there is influenced by his use of controlled substances. And I don't think that that is surprising. You know, it's not a surprising thing to see. We know that controlled substances and the convictions that come from them can come in a variety of different forms. They're not always sort of overtly controlled substance offenses. Additionally, I would point out, you know, certainly he has engaged in treatment in the past. I hesitate to say that the treatment isn't successful if there is a relapse in the future, just because we know it's not a straight line to sobriety. He might have periods of success. He may have relapses. That doesn't mean that every time he's engaging in treatment, he's not getting better and getting closer to the ultimate goal that we want, which is sustained sobriety.
Thank you, Mr. Truce. Mr. Johnson, is there anything that you want to say?
Your Honor, yeah, I don't know, but I've made a lot of mistakes. All my mistakes are wrapped around my substance abuse. I wrote this poem about heroin, which is my DOC, my drug of choice, and I would like to read it to the court just to give a good wrap around like what it's cost me and like how I'm just done with it. And it goes,
that, sir.
if only I listened to the rumors that turned out to be true facts. When I heard about your powers, I laughed. At the time of my laugh, I couldn't help but to think to myself, how could dust like powder have a touch to give a rush, to grab a man and transform his thoughts? I'll never forget the first time I saw your powder like a silver peg. The first time I saw you, I thought it tastes when it hurt. After trying you, I knew to keep you at a distance, but we would meet a couple more times, which made us inseparable. The more pain you caused me, the more I thought you was helping me, but now it's clear to see you was taking the focus off the real problem. If we were distant for a day or two, I would have a physical change. What a pull you had on me. The drain you once put to my nose is no longer enough, so you became one with my vein, leaving a stain on my skin. Some will call your mark track marks because you hit like a train. For me, it's a reminder of your power, which I gave you a lot of, to the point I allowed you to tell me I couldn't live without you. So I chose you over my family and over my kids. The lower you put me, the higher I put you on a pedestal. At the end of every day, I would say bye to you just to have you tell me in the morning how much I needed you. You took my life 8 times, but yet it made us closer. In the middle of the night, I would scream for help. There's many dark, cold nights I didn't think no one hurt me. But yet here I am in this cell free from you, so you can keep your taste. Because with one slip, I'll be right back in your hold. But also know next time my body be as cold as Alaskan snow. So this is my final goodbye, because if I so happen to say hi just one more time, I won't get the chance to get to say goodbye again. So farewell, old friend. Your Honor, I needed to be incarcerated at the time I got incarcerated. I was on a road to death. That was back in February. In that jail cell, I made a commitment to myself and to my kids that I will put forth every effort to stay on the path that I am on now. I work 50 hours a week. I'm dedicated to my family and to myself. I look in the mirror, I love myself today. I can't change the things I've done, Your Honor. At one time in my life, I used to think that time was our most valuable thing that we had as a human race, but choice. I've learned to realize that my choices is the only valuable thing that I have other than my family, but my choices and for my actions that I create in my life. I can't change everything you read on that paper. I can only show forth what I can have my future look like. And I would love for the opportunity to stay on this road that I'm on right now without any interruptions, but I also know that I haven't made the best choices in the past, and I standing before you in this video willing to own up to whatever circumstances that may occur because of my choices.
Thank you, Mr. Johnson. I was impressed by your poem and the thought and the amount of time and energy that you put into that. I hope it's true. I hope it takes root in you, and all of your future decisions are impacted by that. That would be the best thing. That would be the best of all worlds, as far as I'm concerned. Tell me about your current substance abuse treatment. What are you doing to make sure that this is not going to ever happen again?
I attend 2 NA meetings a week, if possible. Most of the times I do. Most of the time it's 1, but I try to hit 2. I am in Bear River outpatient treatment. I'm in the MAT program. I do take Suboxone. I am prescribed it, but I'm weaning myself down. I'm in therapy with CHS. Just
How often is that?
once a week.
All right.
And I honestly, Your Honor, I work so much where we're working on the new courthouse that's being built in town right now. But I work so much, my therapist told me I kind of replacing work with drugs. I've been working so much. So
Well, that's a healthy swap at least. At least you're not substituting drink for drugs or vice versa. Call it irony. He's now building the courthouse that he's spent so much time in the other courthouses of. Yeah. But good for him. I really hope that this time sticks. I hope he's sincere. I hope he's able to succeed. That's all I want for anybody. I mean, yeah, we dog on people a whole lot. But none of us want to see anyone trapped by their addiction or their mental health struggles or anything that they're going through. Deep down, we all want the best for everyone. But we're all very, very jaded by the number of people that we listen to spew BS at us. Not my pants. I didn't do nothing. I can't breathe. We get sick of it. But I genuinely hope he's able to succeed.
We're working on that, but I'm trying to stay busy.
My only question for you is this. You've had prison time, you've had jail time, you've had past drug convictions, so I know that you've had the access to treatment programs. Why would you come back after all of that and use drugs again?
Just wasn't ready at the time, Your Honor, to be honest. I hadn't lost enough. There's a saying in the recovery community, you know, you're not going to really submit until you're tired. You're just sick of it, sick and tired of it. You lost so much. And at this point, Your Honor, I've lost, there's nothing else I can give other than my life. And I'm on the verge of I don't know if this is gonna help me or not, but honesty is all I can give. I lost my son. I'm trying to get him back. I'm in the process of doing that. I had a vision that I don't want to see come true at all. And I'm doing everything in my power to not let that vision come true, Your Honor. I'm trying my hardest, and I know what I can do, not trying. I want to see what I can do, actually trying my hardest to succeed. And I got an awesome support group. My family is fully behind me. I have a recovery coach that's walked the same steps I've walked and is very successful at this time and has a beautiful family. And I'm trying to make that my version of my life.
With your current employer, Mr. Johnson, is there typically a downtime in the winter?
There's well, I was working for Stonemaster's Masonry and I switched over to Wikis because we got laid off in the winter at Stonemaster's Masonry, and they don't, but there's hours are like go from like 50 to like 30.
What would
So
that time
it's
period be?
I would say in between, I don't want to lie to you, Your Honor, but anywhere from probably like December to February, maybe the beginning of March too. Like
All right, yeah, and I know you can't set it in stone because everybody's jobs are different, so I understand that. I'm just looking for a basic time frame. All right, Mr. Johnson, I'm going to take a chance on you. When I first looked over this case before hearing from the attorneys and from yourself, I thought probably just going to send him to jail. That's kind of where I was looking at it with your history and with the types of drugs that you were using. Again, it wasn't just marijuana, it wasn't just kratom, it wasn't just the small little stuff, it was fentanyl and cocaine. And that's really dangerous stuff in and of itself. And then when I coupled it with your history and some of the violence that I saw in the criminal history, along with the drug charges, I thought this is just a bad guy and he just needs to be warehoused and put away so he doesn't hurt anybody else. But I will agree with your attorney that you do have a great job. And I like the fact that you've been proactive in this. And I like the fact that you put some time and effort into thinking about these things. That doesn't always mean that you follow through with them, but I'm going to give you the chance to do that. How I'm going to kind of keep my eye on you, though, is I'm going to extend the probation for as long as I possibly can. That's 2 years. That means I'm going to watch you for the next 2 years. If you show me any relapse in 2 years, I'm just going to put you in jail because, as you said yourself, you're not ready for it at that point. And I get it that no relapse is a really tight thing to say, because there's no guarantees in life about these kinds of things. But you've used up all of the mulligans that you're ever going to have. Your criminal history is, I'm not going to say abominable, but it's getting pretty close to that. You've hurt yourself, you've hurt your family, you've hurt the people that you've done things against in the past way too often for me to say you get any more chances. So this is it. This is your best opportunity. It's probably going to be your last opportunity. Any other judge that looks at this criminal history and sees, hey, the district court judge put him on probation for 2 years and he was unsuccessful, they're just going to throw you in jail. So I'm going to give you a chance, but I'm telling you all of this by way of saying, don't screw it up. All right. So you'd be on probation for 2 years. There's a probation oversight fee of that for $720. There's a mandatory crime victim fee of $75, a mandatory justice fee assessment of $50, court costs in the amount of $300, fine of $150, and a local charge of $15. Let me add all that up for you. It's a total of $1,310. You can pay that over the course of probation. You must enroll in and successfully complete the recommendation for the substance abuse in the Catholic Human Services report, which includes, well, they recommended inpatient. I think you told me that you're doing outpatient, right? So I'm going to include outpatient treatment and follow the recommendations, which include medically assisted treatment, the NA 1 time a week, and counseling with CHS once a week. While you're on probation, there's no consumption or possession of alcohol or drugs, no entrance into a business where alcohol is served by the glass. It means no bars, even if they happen to serve food. There'll be drug and alcohol testing at the discretion of the probation department. I'm also going to impose community service work at 10 hours per week during December through February, unless you can prove work of 35 hours per week.
That is very smart. You're not working, you're still working. I applaud the judge for that measure.
So if you're working 35 hours a week, great, go do it. That's full time. If you're working less than 35 hours a week, you owe me 10 hours of community service work, and you'll have to discuss that with your probation officer to get approval ahead of time about where you're going to go. But quite frankly, idle hands are the devil's workshop. So to help your sobriety, I want to keep you as busy as humanly possible. So if you can work 50 hours a week someplace, go ahead and do it. At least for now, until you get on a straight and narrow for longer than just a few months. I agree that you've gotten yourself in a good place, but it's only been a few months. So I want to make sure that you stay on that straight and narrow, especially December through February when the construction time really slows down a little bit. I'm not going to put you in jail. I'm not going to impose work camp because I've done the community service work. But I've already told you that the next step, if you mess this up, is jail. And that's just, I'm just going to warehouse you. That's all I can think of to do at the moment, to keep you and the people that you would harm out of harm's way. Any questions about the sentence, sir?
No, Your Honor, but I do thank you for the opportunity to prove my words to be true.
Well, go and prove me right. All right. Good luck to you, sir.
Yes, sir.
You'll need to
Thank you.
You'll need to contact the probation department after the 4th of July. We're off. The court system is, we're almost done with today, and we're off tomorrow for the 4th of July holiday. So on Monday or Tuesday, you'll need to call the probation department. That number is 731.
All right. Thank you, Your Honor. Thank you.
Is that Mr. Wadesky?
Yes, Your Honor.
All right, Mr. Wadewski, I can't see the top head of your top part of your head. There you go. That's great right there. Thank you very much. Do we have Mr. Hamlin with us?
I'm here.
All right, thank you. Mr. Wadewski, we are here today on probation violations from the drug court, the sobriety court program.
Y'all remember him? Yeah, we've done an FTC on him already. So now we get all of the story.
You are currently not, well, let's see, is Mr. Dick here with us?
Judge, this was scheduled, I believe, for 3 o'clock.
I know, but we're trying to get the jail out of,
He was here.
and I thought Mr. Dick was here, so I thought we'd be able to proceed, so.
He's no longer in the
I
courtroom.
had my other witness too logging in at 3.
All right. I apologize to the jail. We'll have to take this up at 3 o'clock with Mr. Wadewski. Could you bring him back at that time, please?
Yeah, I sure can.
Sorry about the problem here.
No problem.
Thank you for being patient, Mr. Wadewski. We're going to call your case next. This is the state of Michigan versus Timothy Wadewski, file 25-6791-FH. This is a probation violation hearing on sobriety court matter. Mr. Hamlin is with us. Mr. Dick is with us. The prosecutor, Mr. Portier, is here, and Officer Gertz is with us as well. Mr. Dick, how does your client wish to proceed today?
Your Honor, Mr. Wadewski, I believe, would like to be able to address the underlying allegations. Mr. Wadewski, if that's not accurate, please say so, and I will request that we have a brief breakout.
Does that mean that he wants to give an explanation, or does that mean he wishes to have a hearing?
Sorry, Judge. My apologies. I believe he still wants to have his hearing today.
Is that
still
correct, Mr. Wadewski?
Sorry.
Yes, Your Honor.
All right. Let me remind everybody what the allegations are, and then I'll ask Mr. Fortier to proceed, and Mr. Hamlin to proceed with their proofs. Starting from the oldest to the most recent, there are, all right. On March 12th, March 12th, 2026, the allegation is that there was a no-show for counseling appointment with Bear River Health. March 22nd, the allegation is that there was a no-call, no-show for a drug screen at Great Lakes Screening and Services. On March 26th, the allegation is there was a no-call for a drug screen at Great Lakes Screening and Services. On April the 10th, 2026, the allegation is a no-call for a scheduled drug screen at Great Lakes Screening and Services. March 31st, 2026, failure to complete community service as per the phase requirements and or failed to abide by the workers' work camp contract to assist in paying off fines and costs. And then finally, May the 11th of 2026, the allegation is that there was assault on hospital staff at Otsego Memorial Hospital and later assaultive activity towards local law enforcement, and that arrest warrants were issued and he was lodged at the county jail on May 22nd. Those are the allegations that have been made against you, Mr. Wadewski. Mr. Fortier, how do you wish to proceed with this?
Your Honor, what I would like to do is address the May 11th issues first, just so that we can get Officer Gertz and Sergeant Prey on our way.
Be happy to do that. Officer Gertz, would you raise your right hand so I can swear you in? You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do, Your Honor.
All right. Thank you very much. Go ahead, Mr. Fortier, as you're questioning.
Thank you. Officer Gertz, where are you presently employed?
At the Gaylord Police Department.
And what's your current capacity there?
I'm a police officer.
Were you working on May 11th of this year?
Yes, I was.
Did you come into contact with Timothy Wadewski on that day?
Yes, I did. What
did you come into contact for Mr. Wadewski?
Myself and Officer Depew were contacted by Otsego Memorial Hospital and informed that they were going to tell Mr. Wadewski that he is going to be placed for treatment based on prior contacts. They want law enforcement there as he has been aggressive with staff and has threatened to leave when this has happened before.
All right, and when you showed up to the, you showed up to the hospital, is that right?
Correct. Yes.
All right, and did you see Mr. Wadesky when you got there?
Yes.
What was his demeanor?
As we got there, the doctor informed Mr. Wadesky that he was being placed for treatment. Mr. Wadesky appeared very agitated with that and verbally advised that he did not want that to happen. We attempted to verbally de-escalate the situation, which continued to rise, and where he began to demand his phone as he had to make phone calls to set things up. We attempted to work with Mr. Wadesky as long as he complied with staff as far as sitting down and trying to calm down. Those attempts did not work, and during that there were several threats to law enforcement and staff that he would do whatever he wants and to be able to get to his phone. He referenced past resisting arrest charges that he has and saying that it would take more officers to restrain him if it became that type of situation. During all of these comments, he did begin banging on doors, kicking cabinets, where hospital staff determined that he was going to be restrained. When that was going on, one of the troopers arrived on scene. Once inside the room, the trooper did have his taser out based on threats towards law enforcement that may become a physical altercation. And during that, Mr. Wadesky was walking towards the trooper. At that time, I took Mr. Wadesky to the ground. We continued to resist. Officers were able to gain compliance through pressure points and basically restraining him and place him into soft restraints.
All right, and just kind of backing up a little bit, when you said he was banging things and seemed to be breaking things, what was that about?
There's a metal roll down door within that hospital room. He was banging out with both fists. He was kicking a lower cabinet to that, which at one point did break off the hinges, and he did pull off, having in his hand when we entered the room. With being a potential weapon is when the taser was then brought out of a holster. To if there was a weapon that we would may have to deploy that. Mr. Wadesky did make multiple comments towards tasers, saying we may have to use them, and even have to use a firearm potentially.
Okay, and how many officers did it take to eventually get Mr. Wadesky restrained?
By the very end of it, it was 5.
And was he struggling the entire time that you guys were trying to get him restrained?
Correct. He was constantly pulling away from us, trying to push us. He did kick one of the officers.
Okay. Are you aware of any charges that arose out of this incident?
I did submit up charges for counts of resisting an arrest and felony destruction of property for the damage to the room.
With the way that he was allegedly screaming about how you're going to have to use a taser, you're going to have to use a gun. I mean, it almost sounds like in his head he was playing Sidle Stew by Cop.
Okay. And are you aware if an arrest warrant was actually issued on those?
Yes, it was.
And I think that's all the questions I have for you right now.
Mr. Dick, cross-examination.
Your Honor. Sorry, I'm plugging in my computer. I mistakenly showed up at court because I was feeling detached from everybody. All right, so Officer Goetz, when you at the hospital, did you have any? Were you briefed by as to any sort of medication that had been administered to Mr. Wadesky?
No, I was not.
Okay. So did you later find out during any sort of investigation whether he had been administered any sort of medication prior to this interaction with him?
During the interaction, he was provided a medication. I'm unsure what it was, in attempts to calm him down. Mr. Wadesky said multiple times that it's not going to work and that he has taken whichever one it was multiple times before. The staff did offer other types of medications, including antipsychotics, and he denied all of those medications.
Okay, but did you find out later on whether or not he had been administered any other medications?
No.
Prior to your engagement? No. Okay. Based on your training and experience, did what kind of let me rephrase that. Based on your training and experience, did Mr. Wadesky appear to be in some sort of a distressed state?
He seemed very upset about the situation. He advised staff that he was there seeking help, and the help that he wanted was medication, and that he very much did not want to be placed into a treatment center.
Okay. Did he appear to be coherent at that time?
Yes.
Okay.
Now, remember, guys, he's in the drug rehab program. So he's having this temper tantrum at the hospital while saying that he wants them to administer drugs to him. That's addict-like behavior if I ain't never heard of it before.
And was Mr. Wadesky responsive to, in your opinion, was Mr. Wadesky responsive to your direction? Or
No.
was it? Okay.
He was advised multiple times to sit down, which he would not do. There was once where he sat down for a couple seconds, but he was advised multiple times to sit down, and we attempted to verbally de-escalate the situation before I had to go any further.
Okay. Do you believe that he was able to, based on your training and experience, believe that he was at that time able to understand and react appropriately to your direction?
Yes, I believe he would have been able to.
Okay. At any later time, was there as part of your investigation or the investigation, or was there a blood analysis perhaps of what might have been in his system at that time?
There was not.
Okay. All right. I guess at the present moment, I have no further questions.
What was in his system? Not enough, apparently.
Thank you.
Any follow up, Mr. Fortier?
No, Your Honor.
All right, can Officer Gertz be excused?
He can.
Mr. Dick?
Yes, Your Honor. He said no to what I would have needed to ask him anyways.
All right.
Yeah.
Your next witness, Mr. Fortier?
Sergeant Ryan Prey.
Sergeant, would you raise your right hand so I can swear you in? You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Do.
All right. Your witness, Mr. Fortier?
Thank you, Your Honor. Sergeant Prey, where are you presently employed?
Gaylord City Police.
And what's your current job description there?
Road patrol.
All right. And how long have you been with the police department?
13 years.
Were you on duty on May 11th of 2026?
Yes.
Do you recall being dispatched to the Otsego Memorial Hospital for an incident involving a patient and a security guard?
Yes.
Can you tell me about that?
We had been told that Mr. Wadesky was at OMH and that there had been some issues with night staff. And later that shift, I was dispatched for an assault on one of the security staff. I made contact with Andrew Goebel. He's a security guard at OMH. He informed me that Mr. Wadesky had exited his room, and he and another security guard had attempted to escort him back into the room, at which point, or when they got into the room, Mr. Wadesky grabbed the security guard, pulling him down onto the bed, put his arm over the back of his head and like under his chin in a modified chokehold. And the security guard informed me that before Mr. Wadesky could lock in the chokehold, he was able to escape. And then they put him in soft restraints. That's the point I walked in when he was being restrained in the bed.
Okay. And did you have the opportunity to review video for that?
Yes, I did.
What did that video show?
Mr. Wadesky was out approximately 10 feet out of the room talking to a security guard. They, both security guards were there. They escort him back to the room. He reaches out towards, I believe it's Mr. Goebel is his name. He pulls him down onto the bed, and he may have hit him first. I can't recall off the top of my head, but he definitely pulls him onto the bed on top of himself and wraps his arm around the back of his neck to under his chin and in a chokehold. And then shortly after, the security guard pops his head out, and then they place him back on the bed and restrain him.
Okay. And are you aware if a felony warrant was issued as a result of this particular incident?
Yes, there was.
All right. And are you aware if Mr. Wadesky was taken into custody on that warrant?
I believe he was taken into custody on the 22nd of May.
Okay. Sergeant Prey, I don't have any further questions for you at this time.
Mr. Dick, cross-examination.
Yes, Sergeant, on the date of this incident, you responded to the initial dispatch call. Is that
Yes, sir.
correct?
Yes, sir.
And is it correct that this incident happened in the emergency room?
Yes, sir.
Okay. And Mr. Wadesky was a patient there, correct?
Yes, sir.
Okay. And do you recall, dispatch did state that the hospital staff were seeking to place him into a mental health facility, correct?
I don't exactly recall the exact words dispatch used, but at some point I did learn that.
Okay. Then, so when you arrived, did you have an understanding that this was a type of mental health or medical situation, not just like a routine traffic stop, for instance?
Yes, sir.
Okay. And hospital staff was already, and their security was already involved before the police contact with Mr. Wadesky, to your knowledge, correct?
As far as tying him down or just keeping him
anything in general.
They were standing by the room. I know that.
Okay. And were you one of the law enforcement officers who took Mr. Wadesky or helped detain Mr. Wadesky?
Are you referring to the incident with Officer Gertz?
Yes, I guess.
Officer Gertz incident happened at like in the morning of the 11th, and mine was at 5 o'clock at night on the 11th.
Oh, understood. My apologies. Yes, I think I was. Okay. All right. So during your incident, were you aware that Mr. Wadesky had been administered sedation previously?
I don't recall. I know generally they won't tell us the exact medication. They'll say they gave him a shot to calm him down, and I don't recall if that was this incident or previous.
Okay. So you were not an eyewitness to the original in the emergency room incident then?
I wasn't witness to either of the incidents in person, no.
Okay. All right. Do you know whether Mr. Wadesky was ultimately petitioned into mental health treatment following this incident?
No, I don't know that.
Okay. But you knew that it was a suicidal patient medical crisis setting?
I knew it was basically a psych patient.
Psych patient? Okay.
Yeah.
So mental health or psychiatric emergency room situation?
Something to that effect.
Right. Okay. Okay. And from what you saw, Mr. Wadesky was only wearing, well, he wasn't wearing his prosthetic, correct?
Correct.
And so he was moving around not under normal circumstances?
He was he hopped his way out of the room and they escorted him back. There was one on each side helping him back into the room.
Okay. But based on the investigation, it appeared that the staff and the officers knew that he was being medically treated for mental health issues.
Yes.
Okay. So as part of the investigation, are you aware whether sedation or medication effects were ruled out as a possibility causing these circumstances?
I was not aware of that at all. He was
Okay.
just not being compliant with staff and attempted to choke a security guard.
Okay. All right. Let's see. Sorry. So your affidavit says that he was in the emergency room because he made suicidal statements, correct?
I'm not 100% sure. I don't have it in front of me right now, and I only have a few minutes to prep for this.
Well, understood. And all right. So before submitting that charge, did you rule out medical incapacity for the assault charges?
I mean, he seemed very capable of making decisions. I've dealt with Mr. Wadesky several times, and even when he is in the hospital, he responds as if he knows what you're talking about and he's following your line of thought when you are talking with him. He's not outside of a normal capacity, I guess, if that makes sense.
Okay. But he did seem to be in some sort of like disorder or panic, correct?
He was upset, but it's a state that I've seen him in several times in the past.
Okay. During those prior incidents, was he under the influence of some sort of like medically administered sedation or things of that nature?
Either medically administered or self-administered.
Okay. All right. I have no further questions. Thank you.
Any follow-up, Mr. Fortier?
No, Your Honor.
May this witness be excused?
He may.
Yes, Your Honor.
Mr. Dick? All right, thank you, officer. Appreciate your
Thanks,
time. Mr. Fortier, any other witnesses or evidence?
Probation Officer Luke Hamlin.
Officer Hamlin, would you raise your right hand so I can swear you in, please? You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
You.
All right, thank you. Your witness, Mr. Fortier?
Mr. Hamlin, where do you presently work?
I currently work for the 87A District Court here in Otsego County.
And what's your job title?
My job title is the Drug Court Probation Officer.
All right, and what are your duties and responsibilities in that role?
My duties in the most simplest and quickest way to say this is to monitor probationers at a very intense pace and rate, Monday through Friday, with a lot of things directed towards counseling, drug screens, and overall attitude during the course of the week or thereafter.
All right, and do you currently supervise an individual named Timothy Wadesky?
Yes, I do.
And is he on, I guess what we would call drug court probation?
He is currently on my caseload, yes.
Okay, so what are essentially some of his requirements that he has to do as part of that probation?
Well, currently Mr. Wadesky is in the third phase, so his requirements are reporting twice a week, both Tuesday and Thursday, which includes random drug screens. That could be anywhere from any day of the week or every day of the week to maybe not testing until on a 10th day of a certain week. He's also got counseling that he has to abide by, group therapy he has to abide by, going to AA meetings no less than 2 times per week, going to the court for his drug court review hearings twice a month on the 2nd and 4th Tuesday of each month.
All right, and what are, for the drug screens, is there a process for that?
Yes, the process for that is every day, Monday through Sunday, between the hours of 4 a.m. and 7 a.m., you make a call to what's called the Redwood Testing Line. The participants are given a phone number, they have a PIN number. That number indicates if they have to take a drug screen or not. If they do, they have to report over to Great Lakes Screening and Services here in Gaylord, which their window of drug screens are between 7 a.m. and 8:30 a.m. There is no specific time they have to show up, but they have to show up in that window.
All right, and what about counseling requirements?
Counseling requirements vary given each phase. I don't have those documents in front of me. If the court does allow me, I can look those up, but each phase has a certain amount of counseling requirement, both individual and group, that they have to attend.
Okay, so Mr. Wadesky is required to attend counseling though?
That is correct.
Okay. So I want to direct your attention to the paperwork I'm showing kind of starts back on March 8th of 2026. Did Mr. Wadesky have to call in that day for a drug screen?
I don't have March 8th in front of me. I have March 12th.
Okay, so let's
the
start with
allegations start March 12th.
March 12th. Okay, so March 12th indicates here that he was a no-show for a scheduled appointment with Bear River. Can you tell me about that?
I reached out to his counselor, and it's been some time since we spoke. But he was a no-show according to his counselor. She reached out to him asking where he was or what he was doing or something to that effect. And it took him some time to get back to her. Could have been a half hour, maybe an hour tops. But he indicated something to the effect he was sick and wasn't able to attend counseling today.
Okay. And this was for March 12th.
Yes, March 12th.
Okay, and does it sound about right that you weren't aware of this until April 8th?
That's correct. The reason I wasn't aware of it was every month we get invoices for counseling, and in those invoices, it indicates who was a show or who was not a no-show.
Okay, if people who are on drug court probation, specifically Mr. Wadesky, if he misses, say, a drug screen, or if he misses a counseling appointment, or if there's an issue with it, is he required to contact you and let you know about those circumstances?
We're required, it's a tough word for me to answer, but he should, because the program is about accountability and honesty. So he should report the incident.
Okay. And on March 22nd, 2026, was Mr. Wadesky required to do a drug screen that day, or to call in for a drug screen that day?
Yes, again, every day, Monday through Sunday, weekends, holidays included, yes.
Okay. Did he call in on March 22nd, 2026?
He did not call in on that particular day.
Okay. Did he notify you that he didn't call in that day?
Judge, can I have a minute to review the paperwork?
Certainly.
Can you ask your question again, Mr. Portier?
Yeah, so did Mr. Wadesky notify you on March 22nd that he didn't call in?
He notified me after his release from jail that he didn't call in because he was under the assumption that, I can't remember the words we used, start fresh, start new the following week.
Okay. And then on March 26th, did he call in that day to see if he had to take a drug screen?
That particular day, he did not.
Okay. Did he show up that day still to take a drug screen?
If the sanction report just says he was no call, that's all he was. So that would indicate he did show up if he had to, but without looking at my paperwork, I can't specifically say.
Okay. I'm looking at the all sanction report just about the note that's in here on March 26th. If taking a look at that would help refresh your recollection, or do you think looking at that would help refresh your recollection?
The judge allows it.
Go ahead.
It's the second to last page on your all sanctions report, Mr. Hinton.
If you're looking at the significant indicators of the report, Mr. Fortier, in bold.
I believe that's the section it's under, yeah.
All right, can you ask your question again, sir?
So did he show up on March 26th to take a drug screen? Or sorry, did he eventually call? Is what I should have asked. I'm sorry.
No, I'm understanding. He did call, but it was after the time of the 7 a.m. cutoff line for the drug court policy.
Okay. And go ahead.
He was talking to me during a scheduled office visit, indicating that his phone was on an update throughout the course of the night. When he woke up, the phone had updated and he was calling past that time.
All right. And when people are placed into drug court, do you go over the policies with them?
Yes, go over the policies, go over what happens if the phone lines are down and or if your phone isn't working. Your phone isn't just subject to be the only phone to call that drug screen line. Any and all phones can call that drug screen line so long as you're able to type in your PIN code.
Okay. And on April 10th, did he call for his to see if he had to drug test that day?
He was a no call on that particular day, sir.
Okay. And Judge, was there also an alleged sanction violation on March 31st? Is that another one of those days?
That is correct.
Okay. Mr. Hamlin, on March 31st, was there an issue with Mr. Wadesky in completing his community service?
Correct.
So what is required of participants in the program as far as community service goes?
Mr. Wadesky is a unique situation. He signed a community service contract to assist in paying off his fines and costs with the court for his current charge. So I, as his probation officer, say kind of forgave the community service per phase requirement and just focused on fines and costs as per that contract with the court.
Okay. And did he comply with that aspect of it on that for that month of March?
He did not.
And you've instructed Mr. Wadesky on all of his requirements in the program, is that right?
Many times over.
And does it sound about right that Mr. Wadesky's been in the program since January of 2025?
Negative. That's an incorrect date.
Okay. How long has he been in the program?
He's been in the program since November of 24.
Okay. So between November of 2024 and all of these sanctions kind of beginning March 12th, you've instructed Mr. Wadesky on what he's required to do.
Yes.
And that's, you said, something that you've done regularly?
Yes.
Are the participants given like a policy manual or anything?
Yes, they're given both a drug court handbook. They're given instructions on how the Redwood testing line works and or operates, and they're also given policy on the sanction protocol with our court.
Okay. Your Honor, I don't believe I have any further questions for Mr. Hamlin at this time.
Thank you. Cross-exam, Mr. Dick?
Yes, Mr. Hamlin, the March 12th no-show for for Mr. Wadesky's counseling with Bear River. Mr. Wadesky provided you with a doctor's note for missing that counseling session, correct?
Do I have that added on to the sanction?
Pardon me?
Do I have it added on to the paperwork?
I do not have a copy of it.
Judge, if I may look.
You may certainly review your records, Mr. Hamlin.
Thank you. So any and all paperwork that I have attached to the sanction dated March 12th of 2026 is the only paperwork I've received from Mr. Wadesky.
Did you happen to have anything in your notes about the doctor's note for that date by chance?
My notes that are reflected in the system that I use for drug court, sir?
Yes, I suppose.
I don't recall putting any note for any doctor appointment there.
Okay. All right, as per the drug court counseling policy, would a participant be able to miss an appointment if they were to provide a doctor's note for an illness? Pardon me.
It's somewhat twofold. One, contacting your probation officer and telling the probation officer I'm too ill to make it to counseling today. And number two, definitely getting a note from a doctor and providing that said proof to your probation officer. A counselor simply cannot just omit somebody from counseling because they told them they're too sick to be there today. It's definitely required proof that you're too ill for an appointment.
Good. All right. On March 22nd, the no call to the testing center. You had mentioned that Mr. Wadesky thought he had some sort of fresh start on the Monday. What was that? Did Mr. Wadesky show you his book and show you an entry stating that?
No, Mr. Dweski and I discussed, I can't remember if it was before him going to jail or after he got out of jail. We did discuss the incident, and to my recollection, it's something about before going to jail that once he got out, he does start fresh and new. But that didn't excuse any call to a drug screen line or any other authority he had to hit.
Yeah, that doesn't make any sense. If that were the case, couldn't all people on drug court or incarcerated or any of those circumstances, couldn't any defendant just decide to start fresh and new at random with their sentence and their testing and requirements? How would that work for domestic violence protection orders? Oh, I'm just gonna start fresh and new today. Knock, knock, knock. No. That doesn't. I guess it makes sense in your drug-ridden brain, but not to the rest of the world.
Okay. Did you explicitly tell him he had to comply with all continued requirements for the drug treatment program after he was released, including sorry, that's going to be a compound question. Go ahead.
Understand your question, but given the times that Mr. Wadesky and I spoke about drug court and its requirements, I think the best answer would be presumed that drug court doesn't stop, because that's something I do tell the participants very routinely, is this program never stops.
Okay. The fact that the fresh start was discussed at some point, did in your mind, is it possible that that could have been misconstrued?
Yes.
Okay,
I
thank you.
would say your argument there is very accurate.
Okay, and moving on to the March 26th no call. You had stated that this was a late call. Is that correct?
Yes.
Okay, and he did test that day. Okay, and then March 31st failed to complete community service as required per phase requirements, or fail to abide by the work camp contract. That violation, so did Mr. Wadesky, actually, what were the hours required by Mr. Wadesky to complete by March 31st?
I believe he and I worked it out so that he was going to work camp 1 day a week, which would be 8 hours every week to assist paying off his fines and costs.
Okay. And this particular one, do you recall the, oops, my apologies. One moment. Do you recall what day of the week March 31st fell on?
I don't recall what day of the week March 31st fell on, but if I may explain the reason why I wrote the violation, I'd be happy to do so.
Yes.
I think it's imperative to notify the court that Mr. Wadesky has not paid on his fines and costs in some time. Mr. Wadesky has not done the community service as per the Otsego County Work Camp contract. It's my obligation to advise the court that little to nothing was completed, as it's part of my duty and responsibilities as a probation officer to do. So that's the only reason I wrote this violation, again, just to bring it to the matter of the court.
Okay, so the is this violation, is it reflective of not completing community service on March 31st or in that week of March 31st?
Again, I don't have a calendar on me, but I would suspect it'd be within the week of March 31st.
Okay, so if all right, do you recall when he next completed work camp, his 8-hour day?
There hasn't been any completion since that sanction was written up.
Okay, all right. And then the April 10th no call, it was just a no call for the testing center, correct? All right. All right, no further questions, Your Honor.
Any follow-up, Mr. Fortier?
No, Your Honor.
All right, you may step down, Mr. Hamlin. Mr. Fortier, any other witnesses or evidence?
No, Your Honor.
Mr. Dick, witnesses or evidence?
No, Your Honor.
Closing statement then, Mr. Fortier.
So, Judge, I think based on the testimony that's been presented here today, there's been a preponderance to show that Mr. Wadesky has violated the drug court program policies by not showing up for his counseling. We heard Mr. Hamlin say that the counselor actually had to reach out to him to find out where he was at, and then he just said, "I'm sick, can't come in." Didn't tell Mr. Hamlin about it. He had to find out when he was processing invoices. He's consistently not calling in for his drug screens, and there's seems to always be some sort of excuse. The phone messed up, or it updated and it did this, and good old fashioned alarm clock probably could have helped. And I think it was Mr. Hamlin that indicated that more than one phone can call the line. They have a pretty significant window to call in, from 4 a.m. to 7 a.m. March 26th, the same thing, didn't called past the cutoff time at 7:31. March 31st, he was, failing to complete his part of a bargain to try to help pay off fines and costs. I don't know that how many hours or whatever he was supposed to do, but it sounds like from Mr. Hamlin's testimony, it was quite significant. At least sounds like maybe 8 hours or so. And then on April 10th, no call, no show for the scheduled drug screen. So I think it's, it's consistent. It's not showing up for counseling, not showing up for his drug screens, or not calling in for his drug screens. And then culminating with these events that occurred on May 11th of this year, where he's in the hospital, he's demanding certain drugs. The hospital's not wanting to give him those drugs. They want to give him something else as medical professionals, and he's refusing it. He's getting testy. It takes 5 officers to hold him down after he's destroying hospital property. He's kicking at one of the officers, kicked him in the chest. Having tasers pulled on him. It just, just shows his behavior is just continuing to elevate into violence. And then, shortly after this incident, the very same day, he's on hospital security camera, fighting with security guards and pulling one of them down onto the bed to try to choke him. And thankfully that officer was able to get free and they got him restrained into the bed. Those charges are both pending. They've been bound over to the circuit court. There's pending resolution in the circuit court. But I think the totality kind of shows that Mr. Wadesky has repeatedly violated the terms of drug court policy. And based on that, I would ask that the court find that he has violated it. Take into account that he's got 7 prior sanctions on top of the numerous prior dismissals that the court has given him chances to basically make amends. And he's continued to do the same thing over and over again. So I would ask that the court unsuccessfully discharge him and have him placed back in front of the sentencing judge, which would be your honor. You sentenced him in January, I think it was January 25th of 2025 was when the judgment sentence was signed for further hearing on what should happen to him after if he's discharged.
Thank you, Mr. Portier. Mr. Dick, your comments?
Yes, Your Honor. As it pertains to the specific violation or allegations that the prosecution was not able to sustain their burden, I would say that, well, pardon me, let me take that back. I would argue that at least the March 22nd no call, there was a discussion with the probation officer, and he acknowledged that their conversation may have been a misunderstanding of whether or not a call needed to be made on the date of the 22nd after being released from jail on the 21st. I would ask that particular allegation be dismissed, Your Honor. The March 12th no show for the scheduled appointment. Excuse me, counselor acknowledged that Mr. Wadesky did respond, letting her know that he was in fact really sick, and Mr. Hamlin was also informed of that, although later on after inquiring about it. The March 26th no call. Mr. Wadesky did in fact test, although his call was according to Mr. Hamlin shortly after the required deadline for the calls. As for work camp, the completion of that, Mr. Hamlin did make a statement that it was not completed. So I will not address that any further. Likewise for the April 10th no call, Your Honor. The May 11th incident, Your Honor. So for a person to generally culpable of this of an offense, or even like the probation violation here, Mr. Wadesky would need to have been able to know what was being done or what he was doing, or know that the officers were acting with legal status or legal authority. This particular incident, it was a mental health incident.
BS. This was not a mental health incident. This was a temper tantrum being thrown by a grown man that wanted a fix. This was not a mental health crisis. He was acting like a 300-pound toddler, kicking cabinets until they broke off, throwing things, putting an officer in a chokehold. Absolutely antisocial behavior. No. And all the while demanding drugs. Not ones that they wanted to give him. He had a list of particular ones he wanted. No, this was a temper tantrum. You can't dumb this one down to mental health crisis. No, you can't justify this kind of behavior. Knock it off.
Both law enforcement officers did testify that they did respond to the hospital because of the individual being there on some sort of a mental health issue, and that Mr. Wodeski was being ultimately petitioned. Your Honor, the fact that he was being petitioned and not voluntarily admitting himself for the mental health treatment, it does reflect that he was not coherent of the incident, not understanding of what's going on. Your Honor, for him to violate the drug court policy or this particular incident, he needs to knowingly have acted in this matter. I believe that the preponderance of the evidence weighs against the Mr. Wodeski being coherent of the situation. The officers did not know whether he had been administered any sedatives or medication prior to the other officer's arrival. There was the acknowledgement of some additional sedatives being administered during the scuffle. And Your Honor, I think that in this particular incident that the court should find that this did not, the prosecutor did not meet the burden on that particular allegation. That being said, I do know that Mr. Wodeski has put in much effort here in the treatment court. I do not believe that the court or anyone else would say otherwise. And I think that Mr. Wodeski, if nothing else, he's honest, and he himself would say that there have been some struggles throughout this entire process. I'll save it for any. I guess the other thing that I would like to just mention is that he seems to have done pretty well for somebody who has been struggling so much with his mental health and addiction. And I think that I ask that the court would consider all of that also in deciding what to do with Mr. Wodeski. Thank you, Your Honor.
Thank you, Mr. Dick. As to the allegations specifically against Mr. Wodeski, the burden of proof of the probation department is by a preponderance of the evidence. I have considered the testimony of Officer Gertz, Sergeant Prey, and Probation Officer Hamlin, including cross-examination of them. As to the March 12th, 26 allegations, there was a no-show for a counseling appointment at Bear River. I do believe by a preponderance of the evidence, there was a no-show for that. Mr. Wadesky claimed that he was sick to the counselor, but as Mr. Hamlin testified, counselor is not able to relieve him of that duty and requirement to report to counseling as required. And I would simply point out, as I'll make a record of this in just a minute, as to his violation history, there are approximately 18 or 19 different allegations against Mr. Wadesky from starting in December of 2024 through beginning of March 2026, most of which were ending in a violation or a combination of violations, some of which were dismissed, but all of them involving either a no call or a no show. So it's very clear to me that Mr. Wadesky on multiple prior occasions was informed of the requirements for calling and showing up, and knew very well that simply claiming to be sick without proving it by a doctor's note and by contacting his probation officer would not be sufficient. So I do find by a preponderance of the evidence that he's committed the violation on March the 12th. On March 22nd, the allegation is that there was a no call, no show for a drug screen at Great Lakes. And this is the one where counsel asks me to find that there was a misunderstanding, that it was a fresh start. And again, for the same reason that I noted the previous violation, there's been approximately 18 or 19 of these no call, no shows, either for counseling or for his drug screening process. So he knew very well what the drug screening process was. And to say that even if an offhand comment of a fresh start is made, that stops you from having a duty to report when you're supposed to report or call when you're supposed to call, it simply boggles my mind given the amount of time and effort and energy that we put into Mr. Wadesky under these same or similar circumstances in the past. So I do find by a preponderance of the evidence that he was a no call, no show on March the 22nd of 2026. On March the 26th of 2026, again, the allegation is he was a no call for a drug screen at Great Lakes Services. This is when he did show up, did call, but he called late. And again, his history of problems with this, he was told in court a number of times by myself. I know that he's had this same conversation with his probation officer a number of times about when he's supposed to call and under what circumstances he's supposed to call, and that there is a hard line at 7 a.m. And he's been, I believe, had violations for this exact same thing in the past. So I believe he knew that. And so I do find by a preponderance of the evidence that he did fail to call within the time frames on March 26th. So I find that that violation has occurred as well. On March 31st, 2026, the failure to complete community service per the contract. The contract was given to Mr. Wadesky individually and very specifically so that he could have an opportunity to pay off his fines and costs, because he was having some difficulty with his employment and his treatment programs. And we were working with him to a very great extent on to make sure that he could attend his inpatient treatments that he went to in, I believe, March and April of I got the dates wrong on that, but there was a time period when he left the program and we didn't require him to do anything because we knew that he was in inpatient treatment program, both for his mental health and for his substance abuse. And so we gave him an opportunity to come back into the program and continue to work through the work camp, and he was supposed to report once a week to that. And so that process was made very clear to him over a number of different time frames, and he failed to complete the community service as required and hasn't made a payment since. So I do find that violation has occurred as well on March 31st. On April 10th, there was a no call, April 10th to 26th, a no call for a scheduled drug screen at Great Lakes Screening and Services. And again, for the reasons I've indicated in the past, I believe that Mr. Wadesky was very well aware, and there's approximately 18 times in the past that he's been sanctioned or talked to about it in court or with the probation officer So it's very clear to me that he knew what he was doing and he failed to call and is responsible by a preponderance of the evidence for the no call on April 10th. And then finally, the one that concerns me the most is the allegations of what occurred on May 11th at the Otsego Memorial Hospital, both at the morning incident with the police officers for resisting and obstructing, and for the evening incident, which occurred with the choking incident of hospital staff. I find that the testimony of the police officers was highly credible, was sufficiently detailed to allow me to understand what happened there. And I find that the backup of the video that Sergeant Ryan Prey viewed that confirmed in his eyes what occurred with the choking incident all shows me that physical incident occurred. Defense counsel has argued that while the physical incident may have occurred, Mr. Wadesky, who struggles with his mental health and has struggled over a long period of time with his mental health, simply didn't know what he was doing or was not, should not be held responsible for what he was doing. But unfortunately for Mr. Wadesky, the testimony was that he was not acting violently, or at least as much violently, before he was told that he was going to go to inpatient treatment. And the violence that was testified to by the officers occurred only after the staff at the hospital informed him that he was going to go to inpatient treatment. And then it then escalated, and Mr. Wadesky was making threats to the police officers and to the staff. He was breaking things in response to that. He had a very violent and long-term violent reaction to that over a number of minutes, and to various officers, including those who had had to pull tasers out to try to get him to respond in an appropriate manner.
Like I said, temper tantrum. He's just a big old child.
So it does not appear to me that he was suffering from a mental health incident as much as he was having an anger management problem. And while his mental health may have exacerbated or led to him coming to the hospital, it did not prevent him from understanding what he was doing, that he was escalating in a very violent manner, and could very well have hurt other individuals. In that conclusion is bolstered by the fact that it did not just occur once, but he acted out in a violent manner much later in the evening and had to be returned. He was taken off of the restraints and then had to be returned to the restraints when he choked or attempted to choke out one of the security officers at the hospital. So for all of those reasons, I do find that Mr. Wadesky is responsible by a preponderance of the evidence for a violation of his probation requirements as to the May 11th incident as well. The question then becomes, what do we do about all of this? And so that anyone who is reviewing this, if there's ever an appeal, understands, I'm going to read through the sanction report history just to put on the record all of the things that we've attempted. We found Mr. Wadesky to be in violation for, and those that we have bypassed or dismissed in trying to get him to comply voluntarily. And basically it boils down to every single month that he's been in the program, all the way back from beginning in December, the month after he was allowed to start the program in November 22nd, through the end of this May 11th violation. Every single month he's had a violation of some kind, or at least an allegation of a violation of some kind or another. So he was put on probation on November 22nd. December 5th, he was a no-show for a drug screen at Great Lakes that was dismissed by Judge Cooper. December 27th, he was a no-call, no-show for a drug screen. January 10th, he was a no-call for a drug screen. February 7th of 25, I dismissed a no-show for a scheduled drug screen. February 8th, I dismissed a no-call, no-show for a drug screen. He was on February 15th, he was a no-call for a drug screen. February 20th, he was a no-call for a drug screen. March 28th, he was a no-show for an office visit. April 23rd, no-show. I dismissed that for a drug screen. May 7th, no-show for a scheduled drug screen. I dismissed that. May 7th, late for a scheduled office visit. I dismissed that. May 9th, failed to bring his medication for review. I dismissed that. May 19th was a no-show for a scheduled office visit. I dismissed that. May 26th was a no-show for a scheduled drug screen. I dismissed that. May 28th was a no-show for a scheduled drug screen. I dismissed that. The June 5th was a no-show for a drug screen. I dismissed that. June 7th was a no-show for a drug screen. I dismissed that. July 15th was a no-show for counseling. August 11th was arrested on a warrant for larceny in a building and habitual fourth and subsequently pled to that. In August through November, he was in treatment outside the drug court program. We allowed him to do that so that he could best meet his mental health needs. No sanctions were taken for him, even though he missed a number, approximately 9 no-shows for office visits and for drug screens, but we knew that he was in treatment, so we didn't take any action as to those. However, once he was released from treatment, on November the 11th, he was November 23rd, he was a no call for a drug screen at Great Lakes Screening. December the 4th, he was a no show for individual counseling. January the 11th, a no call and no show for a drug screen at Great Lakes. February 15th, a no call and no show. I dismissed that. March 8th and March 9th, he was a no show for a drug screen at Great Lakes Services, and that brings us to the 6 violations that he had today. So every single month for the last 16 or 18 months, he's had a violation of the drug court policy in one form or another. And I just can't have him in the program if he's not going to be able to meet those requirements. In addition to that, this is his second time while in the program that he has either been convicted of another crime or been charged with another crime. The first one was the larceny in a building on August 11th of 2025, about a year ago. And he's now escalated to, rather than just larceny and property-related crimes, to the allegation is now that I found by a preponderance of the evidence on today's record that he's committed multiple assaultive behaviors towards not only law enforcement, but hospital staff who are trying to assist him in his treatment. So for all of those reasons, I am going to grant the prosecutor's request to dismiss him unsuccessfully from the drug court program, and we will set a resentencing date once a pre-sentence investigation has been done, and that will be set by the court. Anything further today, Mr. Fortier?
Yeah, regarding an updated PSI, do you want me to reach out to Mr. Brunical, who I believe authored the original PSI,
Yes,
to have an
please.
update completed? Okay.
Yes, please. And then that information, once that's completed, will be sent to Mr. Dick, and he can review that with Mr. Wodeski, and we'll have the sentencing date once that's been, or we'll set a sentencing date and allow that process to occur. Mr. Wodeski will be remanded to the custody of the sheriff.
Judge,
That's all for today. Thank you.
I got one housekeeping, Judge.
Go ahead, Mr. Hamlin.
With respects to his fines, I'm not going to ask about circuit court. His balance there is at $991, but his drug court fine currently stands at $390. He's got an outstanding balance at work camp at $73. With the dismissal, which way would the court like to proceed with his drug court $390 fine?
I would like you to give that information to the pre-sentence investigator and include that in any potential recommendation for use at the time of sentencing. And I'll make that decision then so that Mr. Dick has an adequate opportunity to understand what those dollar amounts are and can make any arguments that he wishes to make at that time.
Thank you, sir.
All right. That's all for today. Thank you very much.
Thank you guys very much. I love you all. And I really, really had fun tonight. And hopefully I'll be able to come on tomorrow afternoon since there's not court. Maybe I can find some stuff tonight. Be safe, be well, sleep sweet, and much love.